Good morning, amazing law nerd. It's Thursday, it's December 11th, but it is trial day 9 because it all got messed up over the weekend. Yesterday was a very dense day of testimony, even though it wasn't the longest day of testimony. It felt like we learned so much yesterday. And at the end of stream, I think I was just sitting there going, and then the prosecution rested and the court let the jury know that they were done for the day and reminded the jury that the defense does not have to present a defense, but that the defense case will begin today. And the court is on a very long break because I was going to queue up what was happening today and I had to Zoom with a very long break. And my in-ears are just fighting with me. So we are going to be going into court. We are going to see what's going on and why they are on a long break. I am sure some of you have already seen. Thank you for no spoilers in the chat, because when we decided to cover this case together as a law nerd community, I said December is really crazy, but all of you were like, we've got it with the schedule ups and downs. Let's just roll, and roll we have, because again, you have made the law nerd stream with me the number one place to watch trials. The Live Trials podcast is charting all over YouTube and elsewhere. And of course, we have the largest number of live concurrent viewers of any stream anywhere, which is amazing. And that has been despite a tremendous amount of YouTube hiccups. I know that we have had Team Baker has been getting yeeted out of YouTube. I know you guys have been getting yeeted out of YouTube. We have reached out to everyone we know and they are looking at it. So it's not just our channel, it's YouTube, but who knows what's happening? Here's what I anticipate today. We know we are starting in the defense case, but we know the court gave them homework. So the court was like, homework, you have homework. And the last time the court checked in with the jury, she told them they should have the case late next week. And we know that the defense was pending motions regarding the defendant's guilty pleas in counts 2 and 3. I have seen so much confusion about the defendant's guilty pleas in counts 2 and 3. I talked about it a bit yesterday. I'll talk about it a bit later today, I'm sure. But the defendant pled guilty and admitted to a factual basis for disposing of a body improperly, which was the charge, and for lying to police, which was the charge, obstruction, essentially. But in those factual basis, the prosecution laid out the facts that they would prove at trial, which includes that the defendant disposed of his wife, Anna Walshe, into dumpsters, multiple dumpsters. That does not happen with intact remains. So with that, we are going to go to court for day 9. I am curious to see what's happening. I'm not quite sure what to expect from the defense, but what I know is that their opening statement, and the court tells the jury, opening statements are not evidence, right? But the opening statements said a lot about what Brian Walshe did and what Brian Walshe knew, and nudging Anna Walshe in bed. And the only way that comes into evidence is if Brian Walshe testifies. Allison, this helps. Allison in the chat said, local news and mass is saying he pled guilty to dismembering a body, so it's confusing. There has been a lot of confusion. The charge was not for dismembering a body. The charge was for disposing of a body, but the factual basis necessitates that happened. And when asked about the factual basis, when the prosecutor said at trial, we'll prove this, including dumpsters, the defendant was asked, do you admit essentially what the prosecutor said, those facts? And he said yes, numerous times. So he admitted the factual basis. The only caveat the defense drew on the factual basis, and again, I'll link where I covered that down below, but the only exception the defense took with the factual basis was that because Brian Walshe misled law enforcement, the dumpsters where remains were disposed of were incinerated, or trash within them was incinerated, and the defense says we do not admit to that fact. The defense was not admitting to the fact that because of Brian Walsh's misleading law enforcement, the dumpsters were incinerating. They would not admit to that causal link. And honestly, at the end of the prosecutor's case, the prosecutors did not put in any evidence that the dumpsters had been emptied. Some of them they did, but had been emptied and had been incinerated. They didn't put that on. They also didn't put in anything about whether other knives or kitchen knives were found in the home, which I am disappointed by. I was hoping to see that. I can't imagine crime scene services wouldn't have looked around the kitchen. They could have given their warrants, but those are things I was kind of hoping to have circled back to, because what I saw a lot in the chat was a number of you asking, okay, but why couldn't they find her if she was in the dumpsters? And I think that the jury is probably wondering that too. If they found these things, why didn't they find anything else? And they didn't bring anyone in to present evidence on that. So it is time for us to go to court. I'm curious what's going on because I saw, again, that very long break in the morning. So I'm not quite sure what's gonna happen. And I'm trying to still maintain an open mind, though I have to admit, after the end of the prosecutor's case, I definitely have thoughts and opinions. But again, we are not at the close of evidence, and I am curious as to what's going to happen. So, law nerds, are you ready?
Bring the jury.
It's time to go to court. Well, it's time to see what the judge puts on the record before we go to court, because they still need to talk about the ruling on the motion with the guilty pleas, because she kept asking the defense to narrow down those arguments. So we're going to roll the intro. We're going to go to court, and then we're going to see. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Christy, I was trying to save your chat and the chat was going very fast, but Christy G403 in the chat said, I just found out yesterday that I won 2 national awards in my field and will be showcased in 2 publications next year. Christy, crushing it at the end of the year, and I appreciate you sharing with us. I know there are times, Emily, what are the off-topic rules? Well, we love to celebrate the law nerds. We try not to pull the entire chat off topic, and sometimes that's a moving target, but I appreciate you guys because you are the best. We love celebrating with our law nerds, and we love sometimes when we need to hold other law nerds in support, we do that too. You guys have been wonderful with that.
Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Mr. Connor, I would love to have a chat with you. I have some thoughts. I'm not as mad as I was yesterday, but I'm still a little salty.
Good morning.
I'm still a little salty.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Okay. Hi, Mr. Tipton.
Defendant.
They're waiting for the defendant to come into court because the defendant is not present yet. Normally, the court doesn't start if the defendant's not sitting at table, but the jury's not in and the court is on the bench waiting for the defendant to come walking in. I wonder if they needed time to finish dressing him out for court in his civilian clothes. They would do that at the courthouse, not before he's transported.
Present in the courtroom.
Thank you,
So
Madam Clerk.
the defendant is not present or now present. Also, I'm terribly sad that I'm still sad that Mr. Mootlu didn't get to finish his testimony yesterday. So again, if anyone is friends with Jem Mootlu, if he would like to chat, the law nerds are here to listen. I don't often solicit interviews. I don't do a lot of interviews. I am tremendously focused on just being here with the law nerds, but I'm here. Look, both of the witnesses yesterday, if they want to chat, I'm here to chat. Some of you are like, Emily, you need to keep reading. And I'm like, I'm trying to get my notebook up before we start court for the day. It was just not loaded yet. Things you don't have in a
All right. At the close of yesterday's
paper.
day, the defense raised with me
what I have listed as 5 separate issues that it wanted to
This is what they were doing at sidebar. 5 separate issues at the end of the day yesterday?
alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr.
So they, at the end of day yesterday, anticipated calling him first then. I was wondering if they were going to call him first or last.
Walsh today?
Wait, what? Wait. What? It's not your YouTube, it's me. They asked the court, I'm going to gain our feed up to 5,000 to hear that again. But the court said at the end of the day yesterday, the defense raised 5 issues with us, including the issue or the topic of Mr. Walsh's testimony. And then the court said, do you still plan on calling Mr. Walsh? Tipton got up and said, we do not. What do you mean we do not? What? We're backing up. I want to hear that again. I gained this up.
I've listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh.
Well, day 11.
As an initial matter, does the defense
Or
still intend to call
day
Mr.
9.
Walsh today?
We do not.
You do not?
The court sounds stunned. The court sounds absolutely. Did you hear the judge? I can't write notes. I'm going to have to come back and write notes. Fuck notes. What are we doing? Did you hear the court? They do not. They were going to call him today. And they do not intend calling him. Period. No, they do not intend calling him. Period.
Still intend to call Mr. Walsh today?
We do not.
You do not?
Okay, she did say today.
All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5.
I think they don't intend to call him at all. She said we don't intend to call him today, but if they still intended to call him, if the court spent the overnight, and I imagine the judge was probably working fairly late, if the judge spent the overnight working on 5 issues related to the defendant's testimony, and they are saying that those are moot, they are a moot issue, it's because he's not going to testify. I need clarification. I need to hear that again.
With regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
Are you going to
You
call
do
other
not?
witnesses? She sounds stunned.
All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right.
They're not going to call him at all. She said, you're not going to call the defendant today. And he said, no. And she asked, did the 5 issues I researched last night, are they now all moot, including the issue of his guilty pleas? The only reason the guilty pleas would be moot is if he's not testifying at all. So she's going to have to do a colloquy with him then, right? Tipton looks a bit defeated, y'all.
I will conduct a colloquy with the defendant then now. And my intention,
He's not going to testify.
is
He's not going to
defense intend
testify.
call any other witnesses?
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record. So the record is.
They have to do a colloquy, and the defense is resting. Chat, your motion for code red is granted. We're gonna keep reading. They're not putting on a defense at all. That happened quick. We're gonna watch that one more time, and then I'm gonna grant your motion for code red.
Initial matter, does the defense still intend to call Mr. Walsh today?
We're watching this again.
We do not.
You do not?
The instant replay's worth it. The court researched 5 things last night. Those are all moot.
Researched last night.
They're
I
resting.
apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
No
All
witnesses.
right, then we'll
No
close
witnesses.
tomorrow. We'll do the charge conference immediately after the rest of the day.
They're going to close tomorrow and do the charge conference. We're going to watch the charge conference. The charge conference is the jury instructions. It's important. Yeah, yes, code red. Yes, code red. Motion granted. For those of you that are new here, I normally talk. I am stunned that the defense is resting. And here's why I'm stunned before we go to code red. If any of you are new here, just put a 1 in the chat. For any of you that are new here, know that I do not poll on questions for the jury. There is much we are going to have to talk about. For those of you that are also new here, when we go to code red, it is a bit flashy. We're going to go to code red in just a second. I'm fucking stunned. That's why the court took such a long break then. Well, now we know, because the court asked the defense to take up the 5 issues that they addressed with the court at sidebar yesterday related to the defendant's expected testimony today, which we all anticipated, because in opening statement, the defense told us a whole bunch of shit that we can only know from the defendant. Because I think the defense attorneys also intended that the defendant would testify. Because he said Brian Walsh went to bed. His wife was non-responsive and he nudged her. That's not in evidence. The defendant is not testifying. The defense is calling no witnesses. The defense is resting, and they are closing tomorrow. The court told the jury that they would be closing next week, which means in all of the conferences when the court was talking to the defense about scheduling, the defense anticipated at least several days of their case. At least several days of their case. The court sounded shocked. She didn't buffer as much as I did. The court sounded shocked. Because the court spent the evening, after court, researching all the issues with the defendant's testimony. I imagine the prosecution is sitting in court also stunned. Because I imagine that the prosecution also slept for about 3 hours, preparing for the anticipation of the defendant's testimony today. And after, I think his lawyers probably anticipated it, and something changed yesterday. And the defendant chose not to testify, and the defense is calling no witnesses. I am buffering. What the fuck? We're going to watch the colloquy with the defendant because the court has to ask the defendant. The defense does not make this decision. The defendant makes this decision. We have seen attorneys disagree, sometimes strongly, with what their client is choosing to do. But this decision rests solely in the hands of the defendant. And I am trying not to break my own chat rules because this entire case, every strategy in this defense case was to give him the best ground to testify. But day after day in this case, we have talked about the difficulty of a purely circumstantial case with no cause of death. And I said our nuanced legal conversations about what is the time for premeditation And when is a decision made? And how do you put yourself into someone's mind and decide whether they decided to commit a murder when you don't have an autopsy? Because oftentimes the autopsy is incredibly telling. Somebody didn't trip and fall and strangle themselves. You can tell. But the jury doesn't have an autopsy. They don't have remains that were recovered. And I said, those nuanced conversations about the jury instructions and the law might go right out the fucking window the second the defendant opens his mouth. I wonder if he thought so too. Because he's not testifying. And I am at full code WTF. I'm stunned. I'm stunned. I thought there would be some wiggle on Donna Adelson. I thought that she might testify, but she saw how it went for Charlie Adelson, and her defense did not promise anything from her in opening. The defense promised the jury Brian Walsh's side in opening statement. The defense does not have to put on a defense. And I think that the nuanced legal argument is what they are going for. I think they are going to try to look at the jury tomorrow in closing, and say, can you say to a moral certainty how Anna Walsh died? Can you say to a moral certainty that Brian Walsh planned it? Because he did not kill his wife. They admitted to the Google searches in opening. They conceded the Google searches in opening. And they didn't really fight on the tech evidence all that much because they conceded that he freaked out after he found her deceased. I mean, that's not what the videos from Lowe's look like. We have so much to talk about today. We're going to Code Red. Law nerds. How you doing? Wow. All right, we're going to go to the colloquy, and then I wonder if they took the break so that they could do jury instructions. And we're going to listen. It's called a charging conference. We're going to listen to them do the jury instructions. Jury instructions might be boring to watch, but they are incredibly important. Motion granted for those of you that are new. It's flashy till the music ends. Code Red. Fuck. The court seems as shocked as we are. I got nothing. A few of you are like, put the chat in slow mode. The chat is in slow mode. There's just we just have a lot of law nerds, which is great. And we have a lot of people who very kindly gift memberships, so it kind of breaks slow mode anyway, because if you remember, you can't be slow moded, which I love about memberships. I don't even know. Are any of you just getting here? I'll back it up one more time. Hold on. We're less than 2 minutes into court this morning. 2 minutes in. I'll let it play with me just sitting here dumbfounded, and we'll see what the colloquy is. We're going to back up again.
With regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not?
The shock from the judge.
All right. Does that moot every issue that I researched last night?
Last night.
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
No.
All right. Then,
no witnesses.
We'll close tomorrow. We'll do the charge conference immediately after the rest of the day.
I'm still stunned.
Let me just put in the record.
You know why the court's so mad too? Because had the defense told them yesterday, and the defendant probably decided this last night, this is not her fault. This is not the defense's fault. I'm not blaming the defense on this. The judge is pissed. The defendant could have changed his mind this morning on the ride to court. He could have seen a car drive by with a license plate that was like 1144 and been like, those are my numbers. I'm not testifying. He could have told his attorneys first thing this morning. Oh, I did forget to turn the lights because I'm so stunned. He could have told his attorneys first thing this morning that this was his choice. They might not have known. Judges hate few things more than burning a jury's time. Judges hate it when their orders are ignored, and they hate burning a jury's time. And calling a jury in to tell them that the defense rests and to come back tomorrow for closing is not ideal. If the court had had a heads up, the court would have told the jurors to just come in tomorrow and not today. Judges, I think most judges, at least all of the judges I have the pleasure to know, consider the jury's time first. They put the jury's time above all else because if members of the community do not come in to serve jury duty, I can't talk, to serve jury duty, none of it works. And they want members of the community to have a good experience and not walk away feeling like their time was wasted. And we saw the jurors in Reed Part 2 starting to get real frustrated with that. While the sidebars, while they're waiting, why are you wasting our time? Judges are very mindful of it. They're going to have to do a colloquy. I've got a coffee and a croissant. I don't even know if I'm going to get to eat my croissant today. Don't worry, we'll get to our Wildgrain sponsor of today's stream in a bit. We'll get there. I can't even eat. I can't eat because it'll just come falling out of my mouth because I am still just dumbfounded. Oh, so many promises made.
So the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously.
Oh, good.
Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying.
And he's not.
But I just want to put in to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously.
You've not put it on the
I want
record
to put
'cause
in
we've
the
been
reason
waiting.
why I excluded that testimony now. The Commonwealth did file a motion.
So the court did rule on the guilty pleas not coming in, and the court told them at sidebar that those weren't coming in. I expected that the court was going to do that, and that's what the court is doing. The court's like, I spent all night getting ready for you, and then just pulled the rug out. Oh boy.
To exclude evidence that the defendant pled guilty to misleading the police and
So the
to
court was
Walsh's
going to keep
disappearance
this out.
and improper disposal
Well, that
of her
answers that
body.
question.
After consideration, I allowed and still am allowing the Commonwealth's motion for two reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I
that's what we figured she was going to do.
I read this morning
rug pulled by the defense
motion
today.
to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe.
This morning?
I have read it.
They just filed it this morning? She's been asking for that for a week.
But it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that...
Your Honor, you're not alone. It's us too. She's buffering in real time. The defense opened with information that was coming in from the defendant's testifying. The defense told the court that they would go through next week. And if the defendant took the stand, it might go through next week. So every indication and what they told the court, because I imagine at sidebar, they said tomorrow we are calling the defendant, so we need to address these things. That's what they would have told her at sidebar yesterday. Because she said the 5 issues I spent last night researching are moot. Because she researched them because the defense told her yesterday the defendant was testifying today. And Tipton seems sedate. But the defendant could have told them all along, I'm testifying. The defendant could have rolled in this morning and been like, yeah, no, I'm not going to do that. The defense might not have known until this morning. because the defense also seems a bit discombobulated. So the judge is also buffering. The judge ruled, so we're clear, the judge ruled, and thank you, Mons, for catching up all the law nerds as they come in. The judge ruled that the defendant's guilty pleas are not coming in. He told them that. The judge told them that yesterday. The judge is making a record about why. And as the judge is making a record about why, she is again indicating that she was of the belief, as were we, that the defendant was testifying today. But the defendant is not testifying. The defense has no witnesses, and they are closing tomorrow. They haven't told the jury yet. The jury's not come in yet this morning. And the judge and I are buffering in real time together. Her hair just looks way better than mine does. Your Honor, what hair dryer are you using? I have questions. The hair has been rocking. I'm surprised the judge didn't just go, "You've got to be kidding me."
As 216.
So this is
That
about
was filed
the guilty
on December
pleas.
11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder.
Wow.
Based on defense counsel's opening statement,
Yeah.
it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this.
Yeah, the
Continuing
colloquy.
with this case, the role of the jury is to make
Colloquies without the jury.
findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence.
Oh!
I also cite to Commonwealth versus Sanchez.
Who's listening in the background? Come on in. Come on in and look at the judge's face for a second.
The role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered.
I was just trying to pause it, and the whole thing jumped. For those of you just coming in, hi. I know, what the fuck. Here's the quick recap. The defendant is not testifying. The judge spent all night preparing for the defendant to testify today because yesterday that's what the defense said they were going to do, and there were issues that needed to be addressed. The judge at sidebar told the defense and the prosecution that she was not allowing the defendant's guilty pleas to count 2 and 3 to come in before the jury, essentially the same way that we have been discussing for days, that if counts 2 and 3 are not to be considered by the jury, the fact that he pled guilty to those does not help the jury make a determination as to a finding of fact as to whether or not he committed the murder. The jury can consider the underlying facts, lying to police, the dismemberment, disposal, and the rest of it, but they don't need to know that he admitted guilt to those things or pled to those things. So the judge is reading into the record part of her finding on that. And I think gave the defendant a pointed look about whether or not that went to the jury's finding of guilt or innocence. I think the court is frustrated about the timing of today. We are still going to have to see the court's colloquy, but she's reading in the rulings that she had made for the record because they happened at sidebar. So at least now we all know there had been many questions about that.
Actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge.
We've heard this. I had to back up a little bit to find us.
Commonwealth versus a juvenile, 396 Mass 108, 112.
She's citing
it's
case law.
well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation.
Emily, you just wanted to see the court. You just wanted to see the court's inflection again. It's a benefit of the feed jumping because I was trying to pause and my cursor was in the wrong place and I totally fucked it up.
From the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge.
Daisy
Indeed,
said
the
in the
defendant
chat,
has not offered any other rationale for the entrance of such evidence. And as was stated,
and a number of you said in the chat they should just do closing today. They can't. They have work to do on the jury instructions because they didn't prep the jury instructions because they anticipated trial going into next week. So I think everybody thought they would have the weekend to finish up the jury instructions, and they don't because the defendant's not testifying, the defense has no other witnesses, and they're closing tomorrow morning. So we're going to hear the colloquy with the defendant, I imagine, after the court's done making the record on her rulings.
Commonwealth versus Ferreira.
And then they got to bring the jury in and tell them to go home.
124, 1977 case. The jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter.
It's moot now because the only way that would come in is him testifying. He's not testifying. It's moot. The court had 5 issues to deal with.
Also filed this morning, 321.
We're going to switch feeds to get closed captioning in just a moment.
Supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will.
This is the Commonwealth's motion in limine to exclude the guilty plea.
Supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
Moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original.
It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's
What did
just
they
not
file?
216, it's 318.
Okay.
All right. On the docket.
So the defendant filed another motion this morning. It was numbered wrong. Let's see what that is. Once they do the colloquy and dismiss the jury,
All
because
right.
they're going to have to do those two things.
Other pleadings up here.
Once they do the colloquy and dismiss the jury, we'll take a pause and talk more. Because then we're going to go to the charging conference. I imagine that's why they were on a long break this morning. We're going to go to the charging conference, which is them discussing the jury instructions, which is really important.
Which I will address in brief.
I'm
One
holding
them
on to
I
a
was
lot
gonna
of your
address
questions.
anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
Mention it all. Mention it all.
So you agree. You knew he wasn't going to testify. You knew he wasn't going to testify in enough time to file a motion about it this morning? You filed a motion about it this morning. So you knew by last night when the judge was handling all the issues related to your client testifying this morning. So you filed a motion, defense, to keep the Commonwealth from mentioning what you said in opening. Look, do not confuse my shock and horror for blaming Tipton. I think Tipton is, look, when you take a case as a defense attorney, oftentimes you have agreed to go to the amusement park, right? To be a defense attorney. You have not agreed to get onto all the rides and the roller coasters with the loop-de-loops. And sometimes your office is like, hey, buddy, we're appointing you this case. And they just strap you in to the roller coaster with all the loop-de-loops. And you're strapped in for the ride. And you got to just do your job. You're just like, we're buckled in, loop-de-loop. Tipton's in the loop-de-loops. Tipton can't get off the ride yet. Tipton is buckled in to the roller coaster. I think when Tipton did his opening, Tipton fully anticipated the defendant testifying because Tipton has shown that he has been really forthcoming and conscientious with the court. I think his client threw in another loop-de-loop. And Tipton is still just buckled into the roller coaster. He can't get off the ride. It's not over yet. And he has no control over where the track goes. So there are some things Tipton had control over before this ride left the station. But right now he's just, please keep your hands and feet inside at all times. Like permanece sentados, por favor. That's where Tipton is. So I don't blame Tipton. But I am frustrated that at least they knew yesterday at some point that the defendant wasn't going to testify. And Tipton now has to try to mitigate what's going on. I don't think this was a tactic. I really don't. I think Tipton looks frustrated, and I don't think Tipton would represent to the jury things he was not confident that were coming in. He does not strike me as that kind of attorney. He has been incredibly conscientious. I think his client switched up on him. Are we shocked? Maybe we shouldn't be, but I think his client switched up on him and he is along for the ride with the extra loop-de-loops, right? So I feel for Tipton. He does look pretty defeated. But now Tipton has to keep going. And so now he has to undo the damage of what he said. So I do not think there's nothing that Tipton has said or done in this trial that gives me any indication that he would roll like this. And it's unethical to present things in opening statement that you do not believe the evidence will show. Tipton does not strike me as the type of attorney who's going to risk his reputation for any defendant because he seems to have a very good reputation. So Tipton, when he made that opening, I think 100% was on board with Brian testifying. We have no idea what Walshe said to Tipton, and we have no idea what changed Walsh's mind. But I think Walshe is the one that blinked. So this is why Tipton now filed the motion to try to fix the fucking damage. Tipton doesn't want to be in a position that he's fixing damage. Tipton would rather have not said it. But over-promising and under-delivering does not sit well with the jury, because don't all of you remember what they said? If you remember nothing else from opening statements, you remember that Tipton was talking about Brian Walshe going to bed next to his wife, finding her unresponsive and nudging her and nudging her and nudging her again to the point that she fell on the floor and then freaking out. All of us still remember parts of the defense closing because it was new information. So I think Tipton is also kind of scrambling to fix it. So let us continue. There, I saw a lot of questions. Schnitzel, 5039 in the chat said, why then not just plead the rest? Because there is a very big question still left for the jury. And if Tipton and Porges can get the jury away from first degree to second degree, then Brian Walshe has a chance at parole, and that's what they are hoping for. Or it could hang. It could hang and have to go to trial again. You could have one juror that's like, I can't tell you what happened beyond a reasonable doubt. I'm not confident on what happened. I'm not confident that there's premeditation. How do I know somebody's been murdered? I mean, the blood evidence is there's a lot of it. So, roller coaster. Let's just, before I start singing the Phineas and Ferb roller coaster song, let's see what Tipton has to say about trying to keep the prosecution from mentioning the fact that the defense said in opening that the defendant was going to tell you all this shit. Let's see. Roller
That's right,
coaster,
and after
roller
consulting with
coaster.
the Commonwealth Attorney, they have no intention, they've told us they have no intention to do it.
Of course the prosecution's going to bring it up.
He promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth Attorney, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law.
The Commonwealth has already told us they have no intention of doing that.
But you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth Attorney, they have no intention, they've told us they have no intention of doing that.
So
Wow.
I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't.
And
the
said
Commonwealth
what?
is allowed to get into it a little bit.
Yeah, they are.
I will alert you to those cases, and
The Commonwealth has told us that they're not doing that. The court, but they can if they want to. Yeah, Commonwealth, why are you backing down? The Commonwealth says they have no intention. Maybe the Commonwealth is like Streisand effect. We don't want to bring it the fuck up. Maybe they forgot. And the court's like, they can if they want. And they can still change their mind because closings are going to be tomorrow.
and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit.
We're going to watch the charge
of my
conference.
research on that issue.
Yeah, we're going to watch the charge conference.
The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that.
The defense does not have to
So
present
now,
evidence.
I do want to conduct the colloquy with the defendant at this point.
The colloquy with the defendant is simply the court's conversation. You'll see it in every case.
Hold on a second, because I'm not sure I have my column.
Yeah, the court doesn't have her colloquy script in front of her because that binder's still in chambers, because what the court was prepared to do today was to take the bench, make a bunch of rulings, and have the defendant take the stand for the next 2 days. That's what the court was ready for today. That's what all of us were ready for today. We were ready for today. And the defendant came in and was like, nope. So the colloquy that the court needs to do is taking a statement from the defendant that he is choosing not to testify and not exercising his right to testify.
It's in my office, so stay tuned. Nobody move.
The court just said the binder I need is in my office. Emily, how do we know that the court was not prepared for the defendant to say he's not testifying today? Well, because her binder to take the colloquy from the defendant about the fact that he's not testifying today is still in chambers, because the court prepared a whole bunch of issues to address the defendant's testimony this morning. And then there was no testimony, and the defense has no other witnesses, and the defense rests. And now they have to do all the jury instructions so they can close tomorrow. So let us take a look at the defendant's colloquy with the court. Fiona Lo-Fi said, wait, I'm confused. Is the Commonwealth allowed to mention the defense's opening? They're allowed to within limits. The Commonwealth told the defense they weren't planning to. It might be full Streisand effect. Like, hey, we're not going to mention it because we don't even want to tell you what they promised you that they didn't show. Because it's also tenuous ground for the prosecution. Let's be fair to the prosecution. Emily, you're jumping the gun on stop backing down. Mount up and ride. Let's be fair. There is a very firm line. All right, the court's coming back in. There is a very firm line on what the prosecution can and can't mention. The prosecution cannot comment on the defendant's right to remain silent. So the prosecution can't get up in closing and say, you didn't hear any other explanation for all this shit. Nobody explained this to you. They can't comment on it. It's improper. If they did, it would cause a mistrial, among possibly other consequences. So to talk about the defense promising evidence that would come in through the defendant can get perilously close to commenting on the defendant's right to remain silent because of the content of opening statement. Now, let's juxtapose Murdaugh real quick. With Alec Murdaugh, Poot got up there in opening, Putin all around, and said, and in fact, we're going to show you who did kill Maggie and Paul. It's much easier for the prosecution, if they choose to in closing, to stand up and say, the defense told you they were going to show you who killed Maggie and Paul, and they didn't. But in that case, the defendant testified and the defense put on an affirmative defense and put on witnesses. So they can comment on what the defense promised and didn't show without treading on the defendant's right to remain silent, which they can't mention. So how does a prosecutor stand up and argue the defense said you would hear how Anna Walshe was found in bed without commenting or getting close to commenting on the defendant's right to remain silent, and without insinuating that you should have heard it from the defendant and he didn't say anything to you? So I can understand that for the Commonwealth, that might be too fine of a needle to thread, and they rather err real far to the side of caution, not real close to the side of we trust the appellate court a lot. They can let the jury sit there and go, but you said he was nudging her in bed. Where the fuck's all that? Didn't see any of that. because the court's going to tell them the defense does not have to put on a defense. They are not obligated to prove anything. And the Commonwealth commenting on what was in opening statements can get very close to, if not crossing the line, of commenting on the defense needing to prove something and therefore shifting the burden. So do you see where the line is for the prosecutor that they might want to just really stay away from and use their time to talk about the knife and the blood and the DNA and the phones and the lies and everything else? Yeah, I can see where they might want to stay away from that line too. Because what you don't want to do is give the appellate court room to get creative, because if he's convicted, it will be appealed. But the defense team looks tired. They look tired. So some of you are saying that Becky asked, didn't the burden shift in the opening? No. They promised things they didn't deliver, but they did not. Well, in the mind of the jury, they might have pulled some burden onto themselves, but they did not burden shift. That's something the prosecution would do.
Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
You having fun? This haha funny? I hope you had a nice moment feeling like you're in control of this courtroom and your attorneys. I hope you enjoyed that. Because we know you're not enjoying custody. So I hope that you felt that this was great. Emily, you've got feelings. Sure do. Sure do have feelings. I'm kind of mad on behalf of his attorneys. Colloquy with the judge, Emily. Maintain composure.
Excuse me.
You can be seated. I was wondering if you were asking me if I wanted him over on the witness stand. I do not.
Nope. Sit over there where I can look at you in your face. The court wishes to not be that close to you, sir.
Mr. Walsh, one important decision that all defendants in every criminal trial
I
need
feel for the defense
to
attorneys.
make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice.
He knows.
I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions.
He knows.
If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify.
We're gonna. They're not gonna. We're gonna.
First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right?
Yep.
Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Okay.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you
Okay.
understand what your attorneys explained to you about your right to testify?
Yes.
Okay.
Has anyone threatened you or promised you anything to get you to give?
What exactly did Tipton say to you when you changed your mind? After he opened on what you were going to tell the jury, what exactly did Tipton say to you? Because boy, I'd like to be a fly on the wall.
Give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
Yes, Your Honor. Excuse me.
If I
Your Honor, can you please ask the defendant what the fuck? Just that. That's it. Just for the law nerds, can you just be like, excuse me, what the fuck? No? Yes, no? Because your attorney opened telling the jury what you were going to say. And at the 11th hour, you blinked. That witness stand looked real scary, didn't it? Yeah. It does. Oh boy. For those of you just coming in, hi. We're at Code Red. The judge spent all night preparing for the defendant to testify today. We thought the defendant was going to testify today. The defendant's not testifying. The defense is resting. The jury's going to get sent home. They haven't been brought out yet, but the jury's going to get sent home and they're going to do jury instructions. And tomorrow they're going to close. And the defense is going to try to fix how badly they under-delivered based on their opening. And if Brian was on the fence about testifying, I am sure that Tipton would have changed his opening. And I'm sure Tipton's opening would have focused on consciousness of guilt. It would have focused on the burden on the prosecutor. It would have focused on, you're not going to hear how Anna Walshe died. The evidence isn't going to show you premeditation. He would have focused on the evidence will not show you that Brian Walshe murdered his wife. He would have focused on that in his opening. He wouldn't have focused on what you're going to hear from Brian Walshe as much. So.
And that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision.
That's my gavel,
bring the
not the
jury.
court's.
Bring the jury.
All right, we're going to switch feeds so we have closed captioning. The court's going to bring the jury, and the jury's going to be dismissed and told to come back tomorrow, which is also going to piss off the judge. Because, no, the jury was not there for any of that.
All rise. Jurors entering.
Those jurors had a lot to think about after that testimony yesterday, as I'm sure you did, law nerds. The prosecutor strategized their witness order, I think, very well and very effectively.
Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court, for your attention, you may be heard. Let's have a call from Massachusetts in this honorable court. Please be seated. Please turn off your cell phone.
Ah! I moused improperly. I was trying to
Morning,
erase.
jurors.
There we go.
Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order?
Your Honor, I love your 4 questions. I think they're great. And as you look at the jurors who have dragged their booties into court this, I'm sure, very cold morning.
That you not speak to anyone about this case.
We're going to go to 1.25.
We're able to comply with my order that you not do any research about the case. Yes.
I put it at
My order that
1.25,
you
and
not
she's
go on
like,
any social media or access any news media. Yes.
oh boy.
And you still all have open minds. Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not.
Hold on. Emily, you're going to almost speed past the end of the case.
With those 4 questions all answered in the affirmative,
The jury
we're
is
ready to
present.
begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench.
The jury came in. They were asked those 4 questions. The defense rests in front of the jury. I really feel for the defense attorneys. I feel for the court. The court came into today prepared to answer a whole bunch of legal issues related to the defendant's testimony. The prosecution came in ready to, I'm sure, deal with the defendant's testimony. I imagine that the prosecutor probably slept a handful of hours last night working on getting ready for cross, even though the defendant probably would have been on the stand all day today. So some of you have asked, would the Commonwealth have withheld things until rebuttal? No, rebuttal's not guaranteed. Rebuttal's not guaranteed in Massachusetts. No, I think we saw the prosecution put on their case the way they were going to put on their case. They put on everything they had. If something comes up, maybe they will recall a witness, maybe not. But even when the defendant says they're going to testify, they have to try their case as if the defense is not going to put on a case. And then be prepared to deal with the defense if they're going to put on a case, because the defendant can always change their mind. And that's what we saw here. So they can't count on what the defense said in opening.
The jurors, I think
And neither
that
can the
approach
jury,
to the
apparently.
trial is, I sort of see it as different chapters of the book. Another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth, all right? So what happens next? What happens next is
Y'all
the
go
next
home.
chapter we're going to go to.
Bye.
Move towards your deliberations. Is that really 2 things that happens interspersed. And the 2 things that need left to be done is I need to give you my jury charge, my legal instructions to you.
Which
And
takes
then
like an hour plus for her to read
closing arguments
tomorrow.
Right. So the way that happens is I will give you when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here. Excuse me.
We will start a little behind real time tomorrow,
Then the
but we'll
lawyers will do
strategize
their
that.
closing arguments, and then I go.
Because the judge is going to read about an hour of jury instructions to the jurors before closing. We'll probably put that at 1.25 so we can zoom a little together and then watch closing closer to real time.
Come back and give you additional instructions. I call them more generalized instructions. So those 2 parts of the trial happen interspersed.
Abda, did we go to law school together?
That's going to happen
did.
tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine.
Yeah, they are
There are
argued on.
instructions and guide instructions. And there, I get the input from the lawyer.
Evelyn, they're going to
What they're
talk about
seeing.
that in the charging
And that
conference.
hasn't happened yet.
And we're going to do that next.
Move at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules. Right?
Emily Outdoors said, did she just say pull them out of her keister? No, she said pull them out of the ether.
To the end. Right?
No, the caller's
Speak to
added.
anyone about this case. Don't do any
Ether.
research
She said
about
pull them
this
out of
case.
the ether.
Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
Fun fact about judicial robes, they are generally choir robes, like church choir robes, and they can add collars to the robes if they like to. But they are not a part of the robe. They are an
Close your
addition.
notebooks and follow me.
Jury out. I'm gonna change our lights back as we get to the charging conference, because who knows, we might need them again. We might need our code red back, and I need to be prepared. Good God, today. Any of you just coming in the chat, welcome. We'll pause in a second because they're going to go to jury instructions, and we're going to watch the charging conference. The charging conference is very important. All right, jury's out. Wow.
Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about
Tell me everything.
during Mr. Moot's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, with the hammer?
No.
Oh, the other one was N, Your Honor.
No, not the
M for
hammer.
identification. Has that been done?
Not the hammer. The report.
This is a question to the defense. On cross.
Page
It's giving, I'm not talking just to talk. This is a question for the defense. Defense? Defense. Defense? I need an answer.
N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross.
page 53 of that transcript.
I want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
So the answer is no, it's not been done.
And just so the record is clear, as I understand it, that
What they're marking for identification is the police report with Mootlu's statements to the police, because they will keep it for the appellate record. So even though it doesn't go into evidence, it's not marked as an exhibit. It's marked for identification so that the record has it.
is a multi-page document of which Mr. Mootlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Yeah, I agree. The defense team looks a little deflated today. I imagine Tipton is
Are the parties ready to do the
Not
charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit.
I don't have a draft for you because of the way things played out, e.g. this entire trial, the defense had said we are going well into next week, so I didn't need to get it to you today. And then things changed.
Of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to Markle instructions. And so you did at my request, and I have had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday. And I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday.
Anybody else run out of steam yesterday? Because I felt the exact same way at the end of the day yesterday. But the judge is, the defense could have sent the judge a heads up, well, that would have been ex parte, and then they would have had to give the prosecution a heads up, and that might have been a strategic choice. But the court's not thrilled. The court will get over it. It's part of her job. She's let them know. She's let the defendant know. But she's still doing her job, because doing work for nothing is not delightful.
I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions. And I made a mental note to go back to those this morning, but I didn't frankly have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday.
Third time she said it.
So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be.
We feel you.
I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
We feel you. Your Honor, you want to know what? You want to know what? I'll tell you. Yesterday after court, I was tired. I was definitely tired. Yesterday was an emotionally draining day, and there was a lot of new information to process. I was tired yesterday too, Your Honor. I do not drink soda often. Coffee, yes. Soda, not often. So yesterday I went to the best place to procure Dr. Pepper because it is spicier and more carbonated than anywhere else. Wendy's, obviously. They were out of Dr. Pepper, Your Honor. I live in the middle of the fucking country. Do you know how long it takes to get to Wendy's? I got to Wendy's. Can I get a Dr. Pepper? We're out of Dr. Pepper. Because Tennessee, the only place I ever have found that they are out of Dr. Pepper. It's the first thing that sells out at the football snack bar too, but you're out of Dr. Pepper. You're out of Dr. Pepper. You're out of Dr. Pepper. Do you know how long it would take me to get to another Wendy's? Because I don't have another 40 minutes to go to another Wendy's. And you know what's not the same? Any other Fountain Wendy's. It's not like we can just go somewhere else. Middle of the country. So I feel you, Your Honor. I worked 10 hours and I just wanted a Wendy's Dr. Pepper. And it didn't happen. Sonic Dr. Pepper Henhouse has to be second. Because Wendy's has the plastic cups and Sonic has the styrofoam cups. It'll tell you a bit about where my ADHD lies on the spectrum. I do not like the feeling of the styrofoam cups as much. Anyone else with me? So, Your Honor, I feel you. I just wanted a Wendy's Dr. Pepper and they were out of fucking Dr. Pepper. For all of you that are new to the chat and you're like, Emily, what are you talking about? I worked 10 hours. I did work 10 hours. But also I will play the clip for you later. I will find it and I will bring you in on the Law and Order joke. We will bring you all together. Don't worry.
That more bluntly, if there's something that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction, potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this.
Your Honor, I feel better about my buffering.
The draft instructions
you're
as
also
I have
buffering
them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means
the facts.
You asked for it.
So the court is telling them, in the draft I'm giving you, I put things in italics if I didn't understand why you want them, so that we can have a conversation about it.
Questioning why you want it. Be prepared to answer that question.
I like her so much.
Or in the instance of
Yeah, it's a weird request.
the
I don't know.
instruction, I have
Given the evidence, it's the facts in this case don't really lend to that.
instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe
The prior conviction.
the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So
Which is
those are
fair.
in italics,
That's fair.
even though the whole instruction isn't in italics.
Yeah, the court has taken a few. The court, look, a huge part of working in law is being able to listen actively. I mean, not interrupt, which was hard for me because there were times my brain was just screaming. This is so much more fun. We have to mask way less, but also being able to read people and being able to read the nonverbal of what's being said. You also have to think on your feet quite a lot and process large amounts of information as it comes in. And
Who's
so the court
closing for the
today
defense?
has done that.
I am.
Tipton's closing
Who's
for defense.
closing for the Commonwealth?
Oh, really? Mr. Connor's not closing. Miss Yas is closing. Interesting. I hear your papers, Your Honor. Yeah, I thought it would have been Connor's too. But I wonder how much they want to talk about Anna, and I wonder if it will ring more true coming from Attorney Yaz. She's flipping through the jury instructions, and because she is the attorney that did the examinations with some of the more emotionally connecting witnesses, it'll be interesting to see how that plays.
The address of the Refuse Center, 300 Forest Street, Peabody.
Yes, Your Honor.
So she is making notes on the jury instructions before they take a break. And then she's going to, I imagine, give them copies so they can go through them. But yes, there's no frustrated keyboard typing, which is great.
The defense now seeking the instruction with regard to the defendant's right not to testify.
I imagine.
I'll add it.
I just want to hear them talk about the lesser includeds.
Commonwealth seeking a motive instruction.
I imagine so.
Yes, Your Honor.
Yeah. For those of you coming in and asking, the jury is out. We're going to get to the jury instructions. The charging conference is
Again, look for the highlighted language.
A very
in the
important part of trial.
consciousness of guilt instruction,
closed captioning
and
go?
see
There it
if
is.
there's some other language you would prefer that adequately captures trial evidence.
The virtual juror asked the consciousness of guilt instruction is going to be in their common set of instructions. She's talking about things that are not already in the common set of instructions.
All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft
We're going to zoom
instructions.
past the break.
And
go to the
I know
charging
you probably want to
conference.
be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge. in
Are
the
they
draft
from
charge.
the MCLE?
So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading.
Your Honor, what lippy are you using?
For my request for jury instructions, and we just provided the name of the instruction from MCLE.
Because it's like
All right.
the judge
I
has
don't
a
know if-
put together
I probably grabbed it.
vibe that I love.
I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked.
Your Honor, you're about ready to like Jordan the Stallion those glasses into the books behind you. Those poor, at least they're not being spun, but these poor glasses, I'm ready for the judge to just be like, just hurl the glasses into the dusty books behind her because the judge is just like, ah! The frustrated fiddling with the glasses is so for real. Unfortunately, I need so many things done to my glasses. If something happened to them, I would just faint because it takes so much effort to make sure that they are tinted and all of the things. But the judge is just like, what are we doing? I'm ready for him. I'm ready for her to throw them. Chat, I've had lovely conversations with Jordan. We met at, I think, VidCon. Very delightful human being. We'll have that conversation another day or maybe later today, but
Talked about the
the
consciousness
judge's
of guilt instruction. and it
glasses
does not-
fiddling is giving
I've never given, as far as I recall,
annoyance.
a version that put my thumb on the weight of the evidence. So it
Yeah.
presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27.
So the court is talking about the language of the instructions and making sure to pick the language of the
Vesting.
instructions that is the most neutral.
I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned.
Mr. Tipton is getting back to the object of the killing must be a human being. is probably older language from older instructions. But he's like, Your Honor, I hope you haven't spent any time on this.
That this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
He said it should have
It's not
been.
an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned.
Yeah, I'm not surprised you're shifting in your seat, defendant. This is like the 15th time today that the court has spent, well, I did spend an awful lot of time on other things.
Quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them.
I like the court's like, well, we learned
I'll take
something
that
together.
object of the killing out.
It was about the friends we made along the
All
way.
right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much
stew.
to change here from what I drafted. 10:30? Sounds good. 10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All right.
So the court is on break. For those of you just coming in, we're going to summarize. I have over 100 questions starred because you have so many of them, but I want to go to the charging conference. I think it will answer some of the questions. So I'm going to do a few questions and then we'll go to the charging conference. Obviously, we expected today to be a longer day. Everyone in court, except for Brian Walshe, expected today to be a longer day. And it seems that the defendant at the 11th hour changed his mind, which just feels real consistent with him. Shimmy said, why is Brian Walshe looking so happy? I am just going to give you my gut reaction to that. You may disagree, but I have found, and I worked a lot of fraud cases, I very much liked working fraud cases, that there is a aspect of control, of being the one in the driver's seat of the decisions that can make people quite happy. And that is the vibe that I'm getting today from Brian Walshe, because this is the, I think this is the time where he got to pull the strings a bit. We'll see how that goes, because I do think that Attorney Tipton probably went into the end of the day yesterday thinking Brian Walshe was going to testify. But I think Attorney Tipton was also caught off guard by all of this, and I imagine he's mad. And if I were the defense attorney, if I were Tipton in this moment, I mean, maybe in his time as a defense attorney, Tipton has put this aside. I also like an aspect of knowing what's happening. I do not do well just being strapped into a freaking roller coaster on a rocket and having to deal with it as it comes. I like to be proactive more than reactive. But I would be somewhat personally mortified, which you have to put aside, that you stood in front of a jury and looked at them and said, this is what the evidence is going to show you. And then you didn't deliver it. And that was outside of your control. I would be frustrated. I'd be a bit embarrassed. And I would be mad. And I imagine Tipton is feeling all of those things. We're going to talk more about that. But remember, I told you, we had lovely sponsors this week that not only keep us making sure that we get you everything on the channel, and Team Baker is well taken care of, but also to take care of the days that YouTube is like, wait, those photos are not super friendly, because there are days that happens in court. And well, every day in court, you've sat here and said, Emily, what are you eating for breakfast? And I've said, I am eating my Wildgrain chocolate croissant. You do not come here for nutritional advice, because I can give you cozy and delicious, That's where the advice ends. So a huge thank you to today's sponsor, Wildgrain. I will say, I don't think this is in our spot for Wildgrain, but we have sent Wildgrain as holiday gifts to family and friends. They have an easier option this year on their website to just send one box for holidays. I have found that people really enjoy it. They have gluten-free boxes, non-gluten-free boxes, so you can choose. But also, if you send it as a gift, call them and say, remember, since things are frozen, you can pull out like 3 cookies. They are gigantic. They are gigantic cookies. And make them at once, because my mother-in-law called and was like, we made all the cookies. She's like, we can't make all the cookies. We're like, oh no, just make 2 and then pull more out of the freezer the next night. Those are my top tips. Thank you to today's sponsor, Wildgrain. We'll be right back, and then we're going to the charging conference. I'm going to cue that up while I show you what I made, because I actually used our Wildgrain to make some soup, and that is in our spot today. Hey, Leonard, is brunch your favorite meal? It's basically my favorite meal because I love breakfast, and brunch is just more breakfast. And one of the things I am so looking forward to this holiday season is that smell of fresh baked goods at my house. But I don't want to have to clean up all the dishes. And with today's sponsor, Wildgrain, you're not going to have to either, because Wildgrain delivers directly to your door artisanal breads, pastas, and pastries that all you have to do is take out of the freezer and bake. One of my favorite things about Wildgrain is that you can pick exactly what you want. So if we are making warm cookies in the evening, I can pick the snickerdoodles. Dr. B can have the chocolate chip, and the kids can choose whatever they want. And for the holidays, they added a tear and share cranberry pecan rolls. And when you purchase a box, they also donate 2 meals to local food banks, including the Greater Boston Food Bank. And when you order, if you want to choose a local charity, you can. If you are ready to go freezer to table in like 25 minutes, no fuss, no mess, I've got you covered. So be sure to use my link in the description and in the chat and use code LAWNERD to get $30 off your first box plus free croissants for life. Make sure you use code LAWNERD for 30% off your first box and free croissants for life. Thanks to Wildgrain for sponsoring this stream and for making me a hero whenever anyone comes to visit and they have delicious fresh baked cookies. Let's get back to it. There's really nothing better than warm cookies, and the smell of the sourdough in the entire house is so good. And yes, I made homemade French onion soup. It was easier than I thought. If you guys want the recipe, I'll put what I used with my sourdough in the members tab, and in the app, I'll send you the recipe I found online. It was easy and it was fantastic. And I want to be a sourdough making girly. I'm also very ADHD. So being able to take it out of the freezer and put it in the oven and be like, I made this, feels delightful, and I can't fuck it up. So I love my Wildgrain, and it's what I eat during trial because I just put it in the oven in the morning. You guys needed a little OnlyFan today. Yeah. Ermadurg said the dopamine. Yeah, I get all the dopamine of baking the things, but without all of the executive functioning of baking the things. And you're never supposed to defrost things, so you don't have to plan in advance. You just pull it out of the freezer and put it in the oven. Perfect. So everyone needs an OnlyFan today. Oh, I promised a summary. Hold on. How many of you just popped in to watch stream? Just go ahead and put a 1 in the chat. Replay crew, I'm so sorry. Today's been a mess. So first thing this morning, the court said I have the 5 issues I prepared. Lots of you just popped in. Hi, everybody. So the court takes the bench, says I have prepared these 5 issues in preparation for the defendant to testify today. So the court worked last night, getting ready for all the legal issues that are going to come up today. And so she asked the defense, is the defendant going to testify today? And the defense said no. No, the defendant's not going to testify. And the court was like, excuse me, what? So the defendant chose not to testify, but the court did say he's not going to testify today. And then the court said, does the defense have any other witnesses? Nope. No witnesses. So the court had the jury come in today for the defense case in chief. The defense has no case in chief. The defense rested. They did the colloquy with the defendant about his choice not to testify. The court made 17,000, I'm a little hyperbolic, 17,000 different comments about how she prepared everything last night for the defendant to testify. And then the court put on the record that the court was not going to permit the jury to hear about the guilty pleas to counts 2 and 3. So counts 2 and 3 are not for the jury to consider because the defendant already pled to them, and the defendant was not going to be allowed to share that he had pled to those. Now, the defendant could have testified and said, I take responsibility for these. I'm telling you, I did those things. You saw me on video, but I didn't kill her. But the court was not going to allow the guilty pleas in. I think the defendant probably wanted those in to bolster his testimony. See, I took responsibility. But I wonder if Alyssa's testimony yesterday made the defendant feel some kind of a way, because the jury heard yesterday how frustrated Anna Walshe was with the fact that the defendant wouldn't just take responsibility and wouldn't just handle the federal case. Now, he told the police joyfully in his police interview that he took responsibility for that with integrity. His words in his interview that was played on day 1. But what we heard yesterday from Alyssa was that one of Anna's biggest frustrations is the defendant wouldn't just take responsibility. And Anna felt it was Brian that was delaying the federal case being done. Do you think that Brian Walshe would say he had to be the caregiver of his kids to avoid going into custody? Does that strike you as something that the defendant would do based on what you've heard from his police interviews? You let me know. Because I think the defendant would absolutely say, you go work in DC. I'm going to stay here and take care of my kids. It's going to take me 3.5 hours to go drop my kids off. That man could have gone to every fucking Wendy's in Massachusetts to find some Dr. Pepper because he has more time on house arrest than I have in my day in any given moment. That man's house arrest was like, take your time. Take your time. You got like 6 hours a day to pick up your kids. He doesn't even live out in the middle of the fucking country. So he's got all the time in the world to go take care of the kids. And boy, was he out and about on house arrest. So we heard that Anna was frustrated that he wouldn't just finish the federal case and that he was the one delaying sentencing. And we heard very early in the case, and I think it'll come up in closing tomorrow, we heard very early in the case that Brian Walshe got house arrest instead of being in custody because he was the primary caregiver for his kids. So the benefit for him is that he was out of custody. And let's not downplay what it meant for him to be the primary caregiver. It meant he was on house arrest. He had like 3 hours in the morning to drop his kids off, like 3 hours in the afternoon to pick his kids up, time to go take care of grooming, like haircuts and what have you, go to the doctor, go to the lawyers. But they never explained that probate attorney, did they? Chad explained it yesterday, but the jury doesn't know. The jury is left to surmise what they may. So he also has a nanny or babysitter. He also has his mother happening or helping. He also can go to his mom's house. He also can go grocery shopping. And because he's not GPSed, if he's back in the front door by the curfew, he's good. So he's got 3 hours to drop the kids off, 2 hours to go home and take a nappy poo, 3 more hours to go pick the kids up, and help at home, and help from his mother, and no job. And he was so relieved to not have his cell phone with him. Girl, please. So do I think that Brian Walshe would delay the sentencing on the federal case because it meant he might have gone into federal custody? I can accept that as a realistic possibility. And if he went to sentencing, which Anna thought he was delaying per her friend, he faced the very, very real possibility of going to federal custody. I wonder if in hindsight, he now thinks that federal custody would have been a better place to be than state custody. I wonder if he is regretting that choice, because if he had gone into federal custody, his life would have played out differently, because that was a fraud case. He wouldn't have been in a higher security prison. Why might the defendant not have wanted to go into custody? Well, going into custody sucks. Fair. He can't come and go as he please. But I also wonder if, after what Anna said to him, that her friend told us, she said that she was falling out of love and that the weight of all of this was stressing her out. I really wonder if he went into custody, if he was worried that Anna was going to move the kids to DC, start a new life in DC, and 3 months into his sentence, send him divorce papers while he's in custody and be like, good luck. I'm out. I got the kids are here. I've got the job. And I wonder if part of him delaying it was not just that being in custody is being in custody, but also that being in custody meant he no longer could call and check on her, call and check on her friends, call and find out where she was. He would have had to acquiesce to not being in charge. I don't know if they'll argue that or not. I'm curious. So him delaying that case is what the jury heard about yesterday. And I'm interested to see in closing how they tie together him being out on house arrest because of the kids and Anna's frustration with the kids not being in DC. Because it seemed that Anna was willing to have all 3 kids up in DC with her. I don't know how Anna felt about the fact that Brian Walshe's mother and I think, was it a cousin or an uncle, were also going to be in DC. I imagine the mother-in-law coming up to DC was not necessarily what she wanted. So I'm curious to see how that plays out in closing. And a number of you in chat are saying that the probate attorney is regarding Brian Walshe's dad's estate. The jury does not know that. There is no evidence of that in this case. All they heard was a big window of time for the probate attorney. That's all they heard. The jury isn't going to have answers to that, and they can't provide answers. No one can provide answers to that question because there's no evidence on the record. I don't even know if there's any evidence on the record that his dad is deceased. There's no evidence. And Brian Walshe can't fill in that gap because no one's testifying. So the jury is just left with this big meeting for a probate attorney and no answers to that. Whether it will stick out to them or not, we'll see. It might not, but they don't have an answer. So we're going to take a look at the jury instructions, because with that, we will hear about the lesser included, and I'm very curious about it. Kylie said, do we know if the jury knows what a probate attorney is? It's going to depend on age, but I think most people are familiar with the word probate, depending on their age, if they have had to deal with it. So age and life experience, jurors are allowed to use common sense, and are allowed to lean into their common sense. There were a lot of questions about lesser includeds. We're going to see that in the charge conference. There were a lot of questions about, does him choosing not to testify impact his appeal? If he is convicted, any issues they appeal are issues they appeal. The decision of him to testify or not to testify doesn't really change that. It just changes the evidence that the jury has before them. Why did the defendant change his mind? We can speculate on that later, but this case is frustrating, like so many criminal cases, in that we might not know a lot of answers. And that's what the defense is going to lean into tomorrow. In closing arguments, the defense is going to lean into, how do you come to a moral certainty? Because that's the language in Massachusetts. Beyond a reasonable doubt to a moral certainty. How do you come to a moral certainty if you don't know how she died? And some of the jurors might go back to the jury room and be like, excuse me, y'all see this knife? But we'll talk about that too. Because the prosecution is no doubt going to come up with things that I have forgotten. The prosecution was talking about the fact that when Brian Walshe said his phone was missing, it was being plugged in and unlocked and locked. So, why are you telling everyone you can't find your phone? And that wasn't after Jem left. Why are you laying the seeds that you can't find your phone with Jem? And why are you saying to Jem, this is the thing, a lot stood out to me yesterday. One of the things that really stood out to me yesterday was Brian Walsh's response to Jem when Jem said, what do you mean she's missing? Did you guys have a fight? Why did it look like we were fighting? Interesting response, isn't it? Let's take a look at the charging conference. We have many questions to answer and lots of conversations to have. What they say in closing is not evidence, but how they explain these jury instructions to the jury is going to matter. Northwest NW, you are a gem and a half. The new phone from December 22nd. December 22nd was also the day he asked for more time on January 1st. Yes, both things on December 22nd. Yes, I had forgotten that the new phone was December 22nd. The new phone was December 22nd, and the request for all the time on January 1st was December 22nd to take his mom home, even though his mom wasn't at his house. Before Christmas. What was he thinking about on December 22nd? And we know it was on the 29th when Anna told her friend that she had answered back to Brian Walshe. This is before New Year's. That she had answered back to Brian Walshe that she was falling out of love. So the new phone was on Brian's account, though. She did not have a phone on his account. She had a phone on her account, not his account. The new phone was on the mom's account, not her account. I don't think the new phone was on December 22nd on the mom's account with the users Diana Walshe and Brian Walshe. Her phone was on a different account, which they talked about early on in the case. So even though she had to get a new phone, that wasn't the new phone that he had. I think the SE was the new phone, and the Mini was his phone, but I would have to go back and look because it was connected to his account. So let us get to jury instructions. There's going to be things we forgot about that they will talk about in closing because it's a lot to take in, and we are not jurors. We are dealing with lots and lots going on in the background. Jurors just have to sit there and watch. Northwest said the SE was the no phone. That's what I thought. The SE was the new phone and the 13 was Brian's. So if the kids all have iPads, why do you need the SE that's on the mom's account? The SE is the phone he used when he was going to all the dumpsters. So we'll see if it comes up in closing. Let's get to jury instructions. I often say that this seems like the most boring part of a trial to civilians. It is one of the most critical parts. The way that the instructions play out for the jury shapes how they see the law. We had to have a moment of the only fan. It felt appropriate because I thought we were going to be in trial all next week, folks. I don't know. I am not prepared. There are lots of things in this case that has left me hanging. This has been incredibly unexpected. I didn't sign up for a roller coaster. I signed up for a trial. I get motion sick. I worked 10 hours. My husband had
We're back on the record in the matter.
My husband had the audacity to say to me, Dr. B, the audacity to say to me yesterday when I was like, and then they didn't have Dr. Pepper. He's like, don't we have a can of Dr. Pepper? Sir, when I am trying to go buy soda from the fountain, soda from the can is not the same. They are fundamentally different things. So yes, there is a can of soda, but that is not the same fucking thing. Soda fountain and can are incredibly different.
The Commonwealth versus Brian Walshe, indictment 2023-0091.
Not the same thing.
All right.
He was trying to help.
Let me make some space over here.
Your Honor, I need to make some space in my brain. I don't know what's happening. It's wild. Exactly. A lot of you are pointing out the Sprite from McDonald's. Sprite from McDonald's is goated. It is the best Sprite, hands down, ever. It is just different. Also, I don't drink soda a lot, so we don't have a lot of soda in the house because I really prefer to get a
I
fountain
know
soda.
you haven't had a long time to look at them, but
If I want a soda.
we'll take a stab at seeing how far we can get today, and then we'll.
No, not this case, Your Honor. I appreciate it. Though I did say, I did make a rug pull reference earlier. We just use the analogies that we use all the time. The jury's not in. The jury's not in.
Reassess whether we need to charge conference a little bit more tomorrow. All right. So,
Charging conference.
my approach to
Let's make
charge
a go.
conferences is pretty informal. And so what I'll ask for each of you to each side is based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way. So an edit or
Damn it, Jenna in the chat said, is
extraction
the gallery
or an
still in?
addition. What's the first page for the Commonwealth?
The media can still be there.
Your Honor, I'd say
The
page
jury's not.
15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number one.
Page 1? Are you joking?
I love it. It's like, do we have 15? I got 15. Anything other than 15? Do we have anything 15? Defense, do we have anything before 15? Page 1. What the fuck? Oh, Her Honor is so funny.
15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number one.
Page 1?
She just took it.
Are you joking?
No. It's, I'm sorry. Premeditation. I'm sorry. I have it one here, but I meant what my notes are saying. It's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1. That
Oh, we need it forever. Page 6, and I'm just lodging.
The feed jumped a little bit because YouTube is YouTubing today, but
It's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1. That
Oh, we need it forever. Page 6, and I'm just lodging my objection, Judge, to otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for the reasons I stated.
No.
All right. I read your motion.
Immediately no. Immediately no. I bet you would love that, Tipton. Immediately no. What did Tipton ask for, chat? Let me tell you what Tipton asked for. Your Honor, I would like you to modify the model jury instruction to remove the timing language of premeditation. The timing language of premeditation indicates that premeditation can happen in a moment. If, say, someone were having an argument in a living room or a bedroom, and somebody left that room and went to the kitchen and grabbed something sharp and then walked back, that is enough to indicate premeditation. They made a choice. They made a conscious choice. That is enough time for premeditation. You do not need evidence of premeditation hours, days, weeks, Google searches before. It can happen in moments. Premeditation can happen between somebody pulling out a gun and deciding to pull the trigger on the gun or take the safety off and pull the trigger. That can be enough time for premeditation. You've chosen to do the act. Different than choosing to push someone. If you choose to push someone because they bumped into you, you're at a bar, somebody bumps into you, and you turn around and are just like, you push somebody, and then something happens and they die. You chose to push them. You did not try to make them die. You tried to push them. I mean, if you want to talk about what a push versus a shove is, go watch, Secret Lives of Mormon Wives. But choosing to push somebody is not going to be easy to argue that they premeditated anything beyond that action of pushing. Though Chad is pointing out, it depends on where you're pushing somebody. That's why I set my example in a bar. Violent femme, it's different if the push is going to cause someone to die. Yes, if you are on a bridge and then push someone off, it's a very different matter. If you're in a bar and somebody bumps into you and you turn around and push them and they fall and hit their head on a table, that wasn't the chain of events that you thought you were going to cause. It's possible, but that's not what you thought you were going to cause. But when we are looking at making the choice to do something that you know can cause someone to die, that's different. Right? So, continuing on, Polly, yes, Polly said, push it real good. Yes. It can happen. There are things that can happen that can cause a chain of events that cause someone to die that the person that pushed the first domino did not intend for it to happen that way. But it can still happen. That's very different than premeditation. He wants the timing language removed. Oh, we haven't used this on the soundboard, I don't think, this entire trial. Where did it go? We haven't used it so much that I forgot where it went.
Survey says.
Yeah. Emily says, this conversation reminds me of my 1L criminal law class and final. Yes, law is very fact specific, even with the push example. Pushing someone off of a bridge or pushing someone in front of a train or a car is very different than pushing someone in a bar, right? So, all right. Let's see what the court actually says instead of my soundboard.
Be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right. I read your motion.
Nope.
Denying your request to make the change. As you know,
Your Honor, your voice said denied the second you said I read your motion. I read your motion. It's giving all but your huckleberry, Your Honor. I read your motion. And counsel, you know that that's not going to happen.
if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case.
That's
so
for
I
the
won't
appellate
modify
court.
the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court.
Your
if
rights
they-
are preserved.
They decide to change the instruction.
Thank you, Judge.
Mhm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9.
Say page
Yes,
1 again.
counsel.
Say
the,
page 1 again.
Instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the
Counsel, were you there for Hacksaw Day? Or the hatchet? Or the Googles about getting DNA off of a knife? Or the knife that was above the refrigerator? This case actually has an abundance of weapons. Counsel, there's also a hammer. And like 2 different pairs of snips. There's like a whole bunch. There's a veritable plethora of weapons. Also, I've seen people give that instruction for things like a skateboard. So, counsel, your rights are preserved.
death of Anna Walsh. And so what the jury is being allowed to do.
What about the breadcrumbs that the call?
I'm waiting for one of the prosecutors to spin round like something out of The Exorcist and be like, are you fucking kidding me? He wants to remove the deadly weapon instruction.
There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walsh. And so what the jury is being allowed to do.
What about the breadcrumbs that the call put down?
What, the breadcrumbs?
Well, why don't you argue, and then I'll let them I don't want to make their argument for them.
Correct.
That would be
Improper.
but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and you'll have an opportunity to rebut.
We'll
I
sit here and make
understand the
faces.
admission of the exhibits. I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever quote weapon, even if you can define it that, and just speculate as to, well, this was.
Counsel, if you can't define a hacksaw covered in the DNA of the victim in the same trash area as the very, very, very bloody carpet, I don't know what counts as a weapon then.
Used, this wasn't used. That is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used.
The jury gets to
without
decide.
any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed. Because
not gonna
all
happen.
it does, well, I'm repeating myself. I'll leave it at that.
Emily says, but the hacksaw was bought after the murder. The jury doesn't necessarily know that. The jury still has to find when the murder happened. The defendant said in his police interviews that she was missing since the first. People said that they hadn't heard from her since the first, but her cell phone's gone. We don't have her iCloud. So we don't know that. the jury might find that it was the second. However, there's also the knife that was in the house. So there are multiple ways that the jury can find the facts. Because if the jury finds that she was gone on the first, because the defendant didn't come in and say that she was deceased, the jury's going to have to decide that. But the knife above the fridge was in the house. I'm bummed that they didn't ask Moot about it. So there's still the knife.
All right, Commonwealth.
Your Honor, I'd suggest from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder.
They found the knife.
Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
Knife.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she.
Google searches regarding DNA on the knife. The knife had the ever-living fuck bleached out of it. So no, there was no DNA on the knife because someone searched how to remove DNA from a knife and then bleached it. Counsel.
You didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
Because
I
why?
did hear you say knife. Didn't I?
No, I didn't hear her say knife just now.
There was a search.
There is a knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that, and then
regarding
it was the search was specific, as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe I can answer this question.
There were two searches with regard to a knife.
There is a slate.com article
Right.
that the defendant went to that was regarding getting can DNA be removed from a knife.
Yes.
Then the dishwasher is
Following that, right?
is follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
It says HIV. That's the HIV search.
I think it's Exhibit 79. Is that right?
It's Exhibit 79.
The
All
court
right.
knows exactly
And
where it
then
is.
Page number 4, the DNA off of a knife,
Yes.
is page 578.
Let me
That's-
get there.
Okay.
Victor said, okay, EDB, it's your fault. I just ordered Wendy's. Did you get a Dr. Pepper? Did you also get
there.
Nuggies? Because their
Okay.
Nuggies are the bomb.
Then if you go to page 670,
Hold on. I just want to look at these.
sure, I
6'7"? Sorry, I had to. I have a 13-year-old.
apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the Binnen's Liquor is also on the first? It's at night because I remember it being a little dark. What
yes,
time is
Your Honor,
that?
it's darker than liquors.
5:30, 4:30, something like
5
that?
p.m., Your Honor.
All right. Okay.
And so if you were to go to page 670,
Yeah. Let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
So the court's looking
Right.
at the
And then
exhibits.
on page 671,
A few of you are asking about the time of the liquor store. The liquor store was closed on New Year's Day. All the liquor stores in Massachusetts were closed on New Year's Day.
there is record 2433. Is it possible that a knife that
which
this-
had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap?
Yes, Your Honor. And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
Does a dishwasher
So,
clean
I think
blood
earlier you referred to breadcrumbs.
and knife?
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the
Or the knife above the refrigerator.
Lowe's trip, where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see what our argument.
Oh, interesting argument, counsel. A lot of you in the chat are asking about the searches regarding HIV. I think it's a red herring to not search DNA and blood specifically. I think it's a red herring to try to throw people off the search. So I don't think it's if you can destroy those traces, it would also destroy blood. It would also destroy DNA. It's just a red herring in the search. And the prosecutor is now starting to talk about the fact that the searches change. The searches start talking about getting blood off of things. And then the searches change to dismembering. So he is talking about the timing of when the searches turn, if you will. So I'm going to hear the prosecutor out on that.
Lowe's trip, where the other articles are bought for the purposes of the dismemberment.
All right, hold on.
The breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip, where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see what our argument is that those searches show the reasonable inference that a weapon was used.
So the inference the prosecution is making is the first searches were in response to how do I clean a murder weapon? And the second searches were, shit, now what do I do? And I think the search, can you be charged with murder if there's no body, maybe leans towards, shit, now what do I do?
All right. There are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall.
Yep, you do.
Instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect to help guide the jury to avoid speculating about
it's in the other instruction.
all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon.
That's for argument.
And use it to find the defendant guilty of first-degree murder. And I'm trying to...
Tipton, that's for argument. They are allowed to make reasonable inferences. You're allowed to define a reasonable inference differently than the prosecution, but there's an instruction about what a reasonable inference is.
Make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
I think I see the writing on the wall is what Tipton said. I think you're right, Tipton, but that's for argument.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite
fulsomely.
completely in other parts of the instruction,
It is.
but I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in, and subject to any additional edits. But I think there's enough there, that the Commonwealth, has presented, as I said, the breadcrumbs.
Yep. I agree with the court on that. Tipton's trying. He is doing his job.
This case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back.
Yeah, but it's Art asked in the chat, Emily, wouldn't anybody with kitchen knives then automatically be quote unquote proven guilty? No, it's not the fact that there are kitchen knives. It is the fact that there was a kitchen knife above the refrigerator that, oh, hold on, we swiped too fast. Let me pull up the kitchen knife and show you what the kitchen knife looked like. And the Google searches. So it's not one thing. This is a circumstantial case, and it's probably a good time for us to have that chat a little bit more again. Circumstantial cases are made up of smaller puzzle pieces than direct evidence cases. All cases are puzzles. And you hope that opening and closing kind of show you the picture on the puzzle box, but all cases are puzzles. In a direct evidence case where you have more direct evidence of a person saw a thing, heard a thing, you have bigger puzzle pieces. When you are dealing with circumstantial evidence, you have smaller puzzle pieces. It doesn't mean that you can't still build the puzzle, but it's gonna take more pieces to put it together than when you are dealing with a puzzle with larger pieces that are a little more easy to ascertain what they are. So any kitchen knife is one thing. This kitchen knife put above the refrigerator in that condition, combined with the other evidence and combined with the Google searches, is a whole different story. If Brian Walshe only had kitchen knives in good condition, in a drawer where you would find the other knives, then I'm not talking about a knife. But this knife above the refrigerator, looking like that, with Google searches regarding how to get DNA off of things, after we know that the defendant cut his finger before he went to Lowe's and bought a hacksaw, I think there's a reasonable inference that because the defendant cut his finger, he was worried that his DNA and her DNA would be on this knife. And it's next to the hydrogen peroxide that we saw him clean. I would have loved if they had asked Jem Mutlu when the defendant was cooking dinner what he was cooking with. If he noticed what utensils he was using. I would love if that question was asked. It wasn't. I wish it was. So it's not just a kitchen knife. It is a kitchen knife that has been rendered unable to be tested because of its condition. And then just someone said, why no bleach on the other weapons? Because when he went to Lowe's, he got Tyvek suits. So I don't think he's worried about whether his DNA is on the other weapons. Her DNA is on the other weapons. His isn't. But at some point, he cut his finger. I don't think he cut his finger when he was dealing with the hacksaw. So he's not worried about that. I don't remember if Jem was asked if Brian had a cut on his thumb, but we did see Brian buying Band-Aids and ointment the next day. And in the trash that they recovered, he had a gauze and tape with his DNA on it in the trash. So there are enough pieces that someone can infer that the gauze and tape with Brian Walsh's blood and DNA on it is from when he cut his thumb, and he bought Band-Aids to deal with the cut on his thumb before he went to Lowe's, before he got the tie-back suit. So why is he worried about getting DNA off of this knife if this is that? So I think there are enough breadcrumbs there for them to make that finding, because the jury gets to decide the facts. So,
And look at the section about
and I do think the defendant was a bit stressed. He looked cool as a cucumber walking around, but the man really couldn't figure out self-checkout for anything. And I think those might have been some leaking signs of stress. So MJ said, I don't understand why he didn't dispose of the knife. He might have simply forgotten that he put it up there. He was going to a lot of different dumpsters. And there was a lot going on, and his kids were home. He might have just forgotten. And I mean, we saw Taylor Shabiznas tell the police in her police interview about the things she forgot in the victim's home. Once he did the steps to handle the thing, he might have just forgotten.
sufficient degree to get this instruction about use of a dangerous weapon, but I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right. So now we'll move to the other
See,
side.
I don't think it's, a lot of people have asked about a trophy. I don't think we are in the realm of serial killer stuff because I view this case through the lens of fraud. And that's also how I view the Murdaugh case. So I view this case through the lens of fraud because the behaviors are consistent with a lot of fraud defendant behaviors. So if I have to group things together, this case is more like Murdaugh to me than like Lisk. It's just, so I don't see fraud defendants try to outsmart. But there were a lot of moving pieces. Joetta asked, Emily, was there never any piece of the victim's body found? There was tissue found with hair, but no, nothing more substantial than that.
I'm moving to page
because the
15.
dumpsters were incinerated.
Did you say 15 into 16?
The impeachment by prior conviction.
Allie
Yes.
asked, how many defense witnesses?
I guess I
None.
lifted part of this language from the defense's request.
The defense
Your Honor,
rested with no
this
witnesses.
appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions.
Because when the defense drafted their instructions, the defendant was going to testify, and then today he didn't. So.
And at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that you're?
They've heard
I
stipulations.
only read the first sentence so far. You've heard evidence. They have through stipulation, right?
Yes, Your Honor,
That sentence is okay.
it's on the next page, only for the limited purpose, and I suggested
I see.
limited
I
purpose.
see. I see.
Margaret asked in the chat, Emily, have you ever seen a defense
Does
lawyer
the whole
quit in
thing
the middle
come
of a
out?
case? They can't. Defense attorneys can't just quit in the middle of the case. Even in some of the cases where, like, again, Taylor Shabusiness attacked her attorney in court, her defense attorney still wasn't off the case. Defense attorneys cannot just quit. They have an ethical duty for their client. And even if defense attorneys try to quit, the court can say, no, you cannot leave until we're done with this case. So no, they cannot quit. Allie asked, what about Erlinda? Erlinda was a prosecutor. Different ethical duties, different situation.
Your Honor, I note in Commonwealth's
defense
motion
attorneys
limine number
can't
12,
just
paper
walk.
198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
That's fair, that it wasn't for impeachment. One of Diddy's attorneys made a motion to withdraw. The court could have denied it, but it was made well before trial, and there were lots of other attorneys, and it wasn't the lead attorney. But attorneys can't just quit. They can make a motion to withdraw. The defendant can try to fire their lawyer, but it's different.
I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I did put that in there last night.
Because it's
based
not
on
impeachment.
the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
The attorneys in Boone did make motions to withdraw, and it was allowed.
Maybe it should be out.
But they can't just walk mid-trial.
So it just seems to me like it should be out.
Oh, you're gonna bounce the whole thing?
It's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh.
Right.
So it just seems to me like it should be out.
We think it should be out.
Then maybe it should be out.
Everybody joins. Great.
It's no longer impeaching
Yeet.
him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Yes.
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right.
It's not impeachment.
My present ruling is that's whole section's coming out now.
It's not impeachment because he didn't testify.
The reason the impeachment by prior inconsistent statement is now in italics is I'm sure that happened with some witness. But I'm not.
I don't know if they had any impeachment by prior inconsistent statements. They had some refreshing the recollection, and they had defendants' own statements to police that were numerous, but it wasn't impeachment. I don't think there was any impeachment with prior inconsistent statements at all. Some of you are saying his police interviews were inconsistent, but it was not impeachment of a witness with their prior inconsistent statement. Those were just inconsistent police interviews. So this instruction goes specifically to if a witness was impeached with their own prior inconsistent statement. Example, like at the grand jury, didn't you say X, but you told this jury Y? More like that.
Not 100% sure.
I don't think it did. At least.
I don't think it did either.
I don't want to speak for-
I don't think it did.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents.
They
I
were
don't know that it
refreshed.
rose to the level of impeachment.
I don't
but
think it did.
there was some questioning of some witnesses about said
Yeah, I just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem.
I very accurately remember that no one fucking grabbed a grand jury transcript and showed it to anyone because I'm still pissed about it from yesterday. Impeachment means on the stand, a witness says statement A, and then an attorney goes, but before you said B. Gotcha. That did not happen in this case.
Yesterday, Mr. Moot yesterday, and that wasn't with a prior
It was refreshing.
statement. It was his prior statement, but he just said, I don't remember. So was that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
Yeet.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined
Yeet.
to take it out.
And we have no objection.
All right,
The
that's
defense
why
has
it
no
was in
objection, it's
italics
out.
before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. Disposal of the evidence of the crime and the lying about what.
The feed is struggling today. I think it just skipped a little bit, but I think it was quick.
Conveying of the body are part and parcel of the murder at this point. Disposal of the evidence of the crime and the
Just a little.
lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the
Right.
case.
I agree. The
It's an
defense is
interesting
thinking.
question.
Linda,
There's
this
many interesting questions in this
There
case, Your Honor,
is.
no doubt.
It's an
Linda, no, this is not the prosecutor doing closing. This prosecutor's argued some of the motions and is there to do some of the motion work.
interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel?
I think it's a chain of events.
Is it prior to this time? Is it prior to the crime that was charged?
Well, the conveying and the lying is after the crime that was charged. There's no dismembering and conveying until after.
Arguably subsequent, Your Honor, but
Right.
I mean, it's arguably
What about the lying
She's
to
not
his
doing
federal
closing.
probation officer?
Miss Yaz is doing closing.
that would appear to be a bad act, arguably a subsequent bad act, but
It's a chain of events.
Yes.
I don't want to interrupt.
Tipton's like, what else are you saying, Commonwealth?
I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book. And I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose.
That's fair.
I think that this jury will probably be asking themselves.
That's fair. And I think what Tipton is saying is, I want to make sure that when we are talking about subsequent bad acts that he is not charged with, that the jury knows where to put that. And Just Call Me Hen said the prior bad act is fraud. It's not, because they're not using the fraud, and they can't use the fraud as a prior bad act. They were using that for motive. The defense is arguing that because the defendant is not, because the jury doesn't have the question of the lying to police and conveyance and disposal of the defendant, that the jury needs to know that what they can consider that for, because that is a subsequent bad act they're arguing after the murder occurred. So it's trying to figure out how to make sure this jury instruction lets the jury know that they can't say because he went and put the stuff, went to the disposals, therefore he committed the murder. Now they can use it as consciousness of guilt, but they can't use it for improper purposes. So it is a legally interesting question because it is a chain of events, but the jury doesn't have to decide those things. If the jury had count 1, 2, and 3, they wouldn't be having this conversation. But because counts 2 and 3 are off the table, there are acts that are not accounted for in any of the charges, and the jury needs to know what to do with that. And that's where they're wrestling with this jury instruction about prior or subsequent bad acts.
I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered.
Sir.
And if they believe that the body was disposed of in bags, anybody's going to think that's a bad act.
What else are they to believe at this point, based on the facts that they're presented?
And they need to be instructed that they can't, he was not charged with anything, and therefore they can only limit.
The question's not before them.
Evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at.
You can't tell the jury he wasn't charged with that. You can tell them the question's not before them and say, you do not have to answer this question.
Your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes,
Attorney
we are.
Tipton? But are you suggesting, I just want to make sure I understand what
He's talking about the dismemberment.
positions are. Are you suggesting then that
'Cause
you
he's-
want that, you want to expand that, so you want an instruction to
Yes.
the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walsh?
Well,
It sounds
And
that
the
way.
lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes,
Okay.
Yes.
but
Do you want that to be included? So in the proposed instruction, and so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad
prior
acts.
bad acts.
I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Shipton.
Yes.
Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other
Yes.
bad acts that I've identified.
He's saying not the
in
art
my
fraud.
Draft
Add
on
the
page
other stuff.
17
Yes.
under impeachment.
yes,
Yes.
Your Honor, I had included, I was anticipating there to
He
be
expanded it.
a proposed other instruction like you had. But yes, I
Okay.
would ask them that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
This would have been
Your Honor, I
easier.
think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement,
I don't know what that camera angle is either, chat.
I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, think the language comes in that defendant hasn't been charged with committing any other crimes other than murder.
Bookish, I think he pled guilty to pave the way for her to testify. I think that's why he pled guilty. But also it does narrow the jury's focus. I've talked about that. We'll talk about it again, I'm sure, when we get to questions. It does narrow the jury's focus onto the more difficult question, because it's...
I'm just pausing there because
some of these things are an easier question.
If the federal art conviction and somebody could wordsmith that and says, oh, yes, he pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You're looking at the first
the only
sentence.
question before them. The only question before them is the murder. And then we have not gotten to the question of lesser includeds. We will. But the jury instructions are all being scrambled, and it feels a little bit more fluid. I mean, she's not sitting on the bench furiously typing like in the Adelson case, but the reason it's shifting is because when the defense made their version of the jury instructions, the anticipation of the defense was that the defendant was going to testify. So these were written through that lens, and now that he didn't, the lens has shifted significantly.
The only charge the defendant is now facing is the charge of murder.
Yes, accurate.
You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walshe and or lying to his federal probation officer. So all four things would go into that parenthetical.
Oh. Really? I want to hear that again. So in the parenthetical, they are going to put the other things in. Magic of Healing Your Soul asked, does the murder include first degree, second degree, etc.? Right now, it is only first degree. We have not gotten to the subsequent potential for lesser includeds. He's not charged with lesser includeds, but they can be added, but we're not there yet. But I'm interested to hear the court adding in the parenthetical of lying to police and disposal.
To the police and or disposing of the body of Anna Walshe and or lying to his federal probation officer. So
and lying to his federal probation officer. Wait it. All four of those things are going in.
Case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walshe and or lying to his federal probation officer. So all four things would go into that parenthetical.
I need to pull the art fraud case. So the jury will hear those four things in the bad acts. They will hear about the art fraud case, lying to his federal probation officer, disposing of a body, and lying to police in this jury instruction.
Officer. So all four things would go into that.
Interesting that the defense is like, yeah, put that in there.
Within 2018.
I think that'll be new information to the jurors. I didn't expect that either, John.
Comma, I'll just put them in date orders.
I backed it up again.
Lying to the police.
You're not glitching.
And or disposing of the body of Anna Walshe.
Disposing
and
of the body of
lying
Anna
to his
Walshe.
federal probation officer. So all four things would go into that parenthetical.
So the jury's going to hear about prior bad act of disposing of the body of Anna Walsh in the jury instructions.
Okay. And then,
So they're going to hear that done, period. I wonder if
then
the defense...
I would pick up with,
Yeah, I had to rewind it a couple times. I wonder if the defense wants that in so that the jury does not feel like that's not been accounted for if they feel that evidence is overwhelming. So in the jury instructions, they are going to be told about the prior bad acts of, prior and subsequent bad acts of art fraud, lying to his federal probation officer, which is also news to me, lying to the police, and disposing of the body of Anna Walsh. All in that jury instruction. That surprises me, honestly.
what the defense says. You may not take the defendant's prior acts as substitute proof for they committed the crime charged, nor may you consider them
prior or subsequent
as proof the defendant has a criminal personality or bad character. And then the rest of that, you
Interesting.
see that all there. All right. What do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder.
I didn't know that he had been charged with lying to his probation officer. No, I didn't. I mean, it seems clear to me that he lied to his probation officer. I didn't know that he had been charged with that. Also, I think that the prosecution is going to argue that on December 22nd, when he told his probation officer he needed to take his mother home for that massive period of time on the 1st, the prosecution is going to argue that that's premeditation. Hearing that, hearing that in here that he lied to his probation officer, I think lends a little bit of weight to that as well. That's interesting.
You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud, and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walsh, semicolon, and or lying to his federal probation officer, end parentheses.
And the
Then
defense
pick
is
up
good
with
with
the
that.
defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes.
So they're
That's
being
where I think
told
I'll
that
end.
they cannot consider this for the purposes of determining if he considered the murder or not. It's interesting. I think the defense, again, wants to narrow down that the jury just has to decide the murder, and it almost signals to the jury the other things are handled. The other things are taken care of. You don't have to worry about those things. Those things are taken care of. You just have to determine the question of the murder. Okay. So that's all going to be read into the jury instruction.
So you're not,
Interesting.
Then I go back. I don't think that's appropriate to add the for one thing.
I'm just surprised.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things.
Because it's a
You can see the
waterfall.
issue that raises.
Yeah, it becomes a domino effect of the other
Your Honor, there's
questions.
also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems
Just reorder
I
it.
don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walsh.
As
that
consciousness of guilt.
Consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page.
It's Fran, and many of you in the chat said, but can't they argue it for consciousness of guilt? Yes, the question that they are on now is prior bad acts, which kind of goes to character. Like, he's guilty of this thing, so he must be guilty of other things. They can say he did these things because he knows he did the other thing. Consciousness of guilt, but not character. Like, criminals, am I right? You can't vibes it. So this is the instruction to try to limit the vibes. The other instructions are, but these actions show that other actions were taken. Hopefully that parsing makes sense. And I think as we hear the instructions together as a set, which is why they're working through them, as we hear the instructions together as a set, it will make more sense.
Page 27.
Oh. Well, I had this all in this section because I thought I'll put the two of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from
And then how
witness
they
credibility to experts.
how they put this in order
makes more
matters. So they are putting the instructions in order also so they make the most sense. These are numbered in the model instructions, and now they are trying to put them in order where they make the most sense.
And move this impeachment paragraph later in the instruction.
I didn't even have a chance to pull the model jury instructions, so I also feel behind. I'm gonna have to pull some of those so that we have them.
What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
I think that makes sense. If you want my opinion.
My comment
They
would
don't.
be, objection to the consciousness of guilt, so.
I know you are.
That's not gonna
It
fly.
seems to make more sense in that area.
Ding ding. He's like, well, I don't acquiesce to the consciousness of guilt instruction. Sir, if there was ever a case to discuss consciousness of guilt, this case comes to the top of consciousness of guilt cases. And that Google search of can you be charged with murder without a body really, really screams loudly.
Move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27.
We're not to page
Recognizing
27
you don't
yet.
want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now.
Your Honor,
To be continued on.
how many
tomorrow. We
years
need
till
to
the
discuss it more.
consciousness of guilt instruction is reworded to
The last two sentences, so I'll just log.
their cooked instruction?
Okay. So lodged.
It's one of these days I can imagine a prosecutor being like, look, chat, jury, look, chat. How do you know they know they're cooked?
What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Consciousness
Nobody
of
likes
guilt.
27. What did I do on that page?
Isn't that consciousness of guilt, Your Honor? Isn't page 27 consciousness of
Let
guilt?
us see. Okay. That's COG.
Ding, ding, ding. There it is.
Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
The instruction you guys want to hear about is consciousness of guilt, separate from prior bad acts. You cannot say that somebody has the character to do something because of things they've done in the past. You can say that these actions indicate a state of mind. And so the state of mind is what they are going to be talking about with consciousness of guilt. Do the defendant's actions elicit a consciousness of guilt? Because why Googling murder if not murder shaped?
In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that that should be tried to conceal the disposal of Anna Walsh's body.
I mean, I think he pretty much, well, did he conceal the disposal of Anna Walsh's body? We saw him on video with big trash bags, but she was not recovered. I mean, he was fairly successful in the disposal because they were not able to recover her, but he is on video.
The defendant may have intentionally made certain false statements before his taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that that should be
fighting with me.
Tried to conceal the disposal of Anna Walsh's body. And in the...
Well, the fact that it was unsuccessful is something you... I mean, there is some evidence that...
I'm going to see if... I'm going to let this roll. If I can find another feed with closed captioning, I might switch because this keeps stuttering. And I do want to hear what they say.
Steps, right? That's not inaccurate.
Correct, Your Honor. That's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
all
accurate.
right. So what do you want me to subtract?
Counsel, just tell her.
Rather than saying taken steps to conceal the disposal of Anna Walsh's body, it's tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
Lawyers.
Counsel's...
So you want me to taken steps to conceal Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the...
I think it sounds like what she's arguing is it's not the disposal. He's not concealing the fact that he disposed of Anna Walsh. It's where we're modifying. He's disposing of Anna Walsh to conceal the murder by disposing of her body, which we know from the Google searches. Okay.
Of the steps to
conceal the body, not the disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word try?
What do you want me to add?
Try.
He tried.
I heard the Commonwealth ask.
Tipton? Was she recovered? No? Okay. It goes beyond a try then. He is very on the spot with his job. I appreciate it. But also...
asking for try.
Commonwealth's content with how the court articulated the...
Well, attempted to take steps.
No, he took steps.
Might be consistent with the evidence, but then that puts my thumb on it a little bit.
He took steps. He did not attempt to take steps. He did not attempt to take steps, Your Honor. We saw him at the dumpsters and Lowe's. Steps were taken.
That was evidence of her body.
That's fair too. Oh, you're thinking about it different than I was thinking about it, Your Honor. I like where your head's at. The court is saying, I don't want to even insinuate that that was her body. So I want to make sure that I am wording it so that we're not like, so you admit there was a murder. There were times when Tipton was asking questions, and I was like, so you admit there was a crime scene. And the court is trying to make sure that her languaging of the jury instruction does not tip the scales of where the jury's at finding facts one way or the other by the way it's worded. So the judge is trying to steer clear of, so you admit what's in the bags is on a Walshe. However, in the other instruction, the jury hears prior bad acts, including disposing of the body of Anna Walshe. So the court is trying to be very mindful. It's like saying, it's a more nuanced parsing of like trying to hide something is you admitting that something's wrong. And she doesn't want that language to look like it's insinuating a fact that the jury should find. Y'all are like, why do lawyers get called on in law school? This is why the Socratic method in law school, because this is very necessary when you are in court.
I thought I heard the Commonwealth asking for trial.
Commonwealth's content with how the court articulated the.
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
Right.
And there I got the language right in the second attempt in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right.
Your Honor, what in the blind squirrel finds a nut once in a while? Like a squirrel trying to find a nut to move your butt on the dance floor. Your Honor, it's just been a delight.
Any other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it, and that objection is noted and lodged.
Your rights are preserved.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Chat is bay.
Yes.
I'm asking that
I like the blind squirrel analogy better than a broken clock is right twice a day. I'm here for
be
it.
included. And I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22.
I'm looking for the consciousness of guilt instruction while I listen to him.
And the heading for that supplemental instruction that's included refers to where evidence is where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intended,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses
Yeah,
that.
that might not make sense.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instruction, because I think just the title alone draws attention to the jury where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in our opinion, to have context for how they use so-called consciousness of guilt evidence.
I don't disagree with that. But doesn't that
The
language,
other thing is, when you talk about consciousness of guilt evidence,
isn't that language in the
case
instruction
law
though,
is
itself?
clear, and the instruction says they can't rely on consciousness of guilt
Alone.
evidence alone. And I think it then, since we don't want the instruction
Well, counsel, it's not alone. Let's be for real.
in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after. Because
I'm just pressing this supplement primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right? And of course, you know this is coming, so you will, I am sure.
Weave it in to your closing.
I know you will. You're going to take those parts of my instructions that you want to highlight to the jury.
Of course.
Put them in part of your closing arguments. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including
Well, I
this
hope
one.
they do.
But anyway.
I may, but
Or not.
having said that,
Tipton, I may.
I guess I just want to ask a question. Do you supply written instructions?
So what I do is I don't
great
give them a
question.
written instruction during the
What Tipton asked is, do you give them written instructions? It's important. When do they get to read along with this? Because it's going to inform whether Tipton puts it up onto a display or not. And I'm interested to hear what the court said. Personally, it would be easier for me. Let me know, chat, where you fall on this. Would it be easier for you to just sit and listen to the court? Or would it be easier for you to have a copy of the instructions and read along while the court's reading it? I think what a lot of courts are concerned about, and what I've seen happen too, is that jurors who think faster than the court can read out loud will read ahead. And then they're not listening to the court. And if jurors start reading along and not listening to the court, then it's a problem. And so what I've seen a lot of judges do is not give the jury a copy so they can't read ahead, but put it up on the display and keep the display at the same page where the judge is. So you can't read ahead, but you can still see it. And I think that is the preference for a lot of courts. So you can't read ahead.
the actual charge. And there's a
So the court's giving her preference.
Just want to ask a question. Do you supply written instructions?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S. that sticks in there, charges instead of charge, or some other
Typo.
less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. I sort of
That's fair.
a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake.
There is.
So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back.
That's just so real.
And my practice.
I would prefer if they could see them on the monitor, but it is so for real. Every judge we've watched has lined something out in pen while they are reading. It is the verbal instructions that are controlling. Also, be honest. If you found a typo in the instructions, would it derail you from listening to the court? They have to listen to the instructions, and there's always a balance of learning styles to listen to the instructions, but they will get a set back with them when they go to deliberate. So the court can modify the instructions, and then they get a set with them when they go back. And it takes the jury time because often the jury will go back to the charging instructions and read them again.
This has sort of varied over the years. I should just send in one. Because I want them around the table talking about the instructions, doing it all together. That became cumbersome. So I've now changed it to I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product,
That's
both
fair.
orally and in writing that I can give them. So if that answers your question, that's how we'll do
Your
it.
Honor, you sound like you come from mergers and
you'll-
acquisitions.
Obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up
very
there
practical.
marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying.
There's always going to be a spare typo.
All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23, including circumstantial evidence in that.
What page you on?
Page 23?
All right, we're now flipping to page 23. Allison in the chat asked over under on there being last minute instruction edits tomorrow. Oh, 100%. There's 100%. Some of you are saying Her Honor has a military background.
Oh, this is the plain language
Love a judge with a military background. Thank you for your service, Your Honor. The precision makes more sense. You and Judge A, the precision makes sense.
version of the circumstantial evidence.
Yes, Your Honor.
The prosecution has submitted a different version of the instruction. And so the court's reading it. I don't think the court's going to stray from the model jury instructions to the other jury instructions. There are numerous versions of model jury instructions elsewhere. And I don't think the court is going to stray from the Supreme Judicial Court model instructions.
Oh, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to, other language that refers to things as language, this is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they.
I'm not surprised that the prosecution has focused on the circumstantial evidence instruction. Are you? Are you surprised? What instruction is the most important to the Commonwealth in this case? Yep.
Proposed.
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence.
And the defense is fine with it.
Indirect as opposed to circumstantial.
If it's
I mean,
raining
it could be
outside,
as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up.
oh,
I don't want to send you something. And
Massachusetts used the mailbox analogy last time about whether a letter had been mailed or not been mailed versus the rain and wet and umbrellas analogy. And she was just talking about that a second ago, saying the mailbox analogy.
you would ask,
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like it's the weekend. Then you don't have to do anything tonight.
I doubt they don't have anything to do tonight, Your Honor. All of them thought they were going to be closing next week. All of them thought they had the weekend to do the closing. All of them. Everyone prepared for the defendant to testify today. Everyone is like, fuck! So I doubt they have nothing to do tonight, Your Honor. I appreciate your optimism.
I'm going to suggest that, but you can do what you want.
A Beautiful Uncurated Life said the judge has a degree in manufacturing engineering and served as an officer in the Air Force and completed her JD in 1991. Engineer, you say? This makes sense. This makes sense. Your Honor, have you met Attorney Jackson? Because also Air Force.
All right. Anything else on the instructions?
Not from the Commonwealth.
All right.
Excuse me, Your Honor. Chat has a question. What homicide instructions are you using? And do they include the instruction for second-degree homicide? Because y'all didn't talk about it, and it's going to stress me the fuck out because I have like 75 questions about it at a minimum. There's like, Your Honor, there's like tens of thousands of people who would like to know if like how much mount up and ride is happening tomorrow. Are they just sending it on the first degree instruction only? Or are you including the second degree instruction? Your Honor, we have questions. If we have to wait till tomorrow.
Really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it.
Your Honor, what chain of events would you like to use? Was FUBAR the word, or were we going more of a shitstorm? What, shit show? Clusterfuck? Dumpster fire? Which one are we going with? Chat, you're welcome to put your guesses in the chat. Replay crew, put your guesses in. What's the non-judicial word that the court is refraining from? I'm going to play that again.
Else on the instructions.
Not from the Commonwealth.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue.
One step ahead of the breath line. No? Anyone? Yeah. Me too.
A couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe.
Okay, before I start singing all of Aladdin, the court is circling back to those of you that are just coming in. Hi. Today has been a non-judicial word, but the court had to be limbo. And now we're here talking about jury instructions. The jury was sent home for the day. The defense had no case. No, that's not the right word. It leaves the wrong impression. The defense chose not to put on evidence and rested. So they are going to be doing closings. At the beginning of the day, the defense had filed a motion, I yelled, trying to preclude the Commonwealth from commenting on the defense's opening statements. Just a few things come to mind, like the defense mentioning that the evidence will show that Brian Walshe got in bed with his wife, Anna Walshe, and she was non-responsive, so he nudged her several times, and then she fell onto the floor, and then he freaked out, those kinds of things. And we had a conversation that I'm sure will be timestamped in replay crew, you can watch it, that the prosecution told the defense that they weren't going to comment on it. And there's a gray zone that can be a real slippery slope there because the Commonwealth cannot comment on the defense's right to remain silent. And it's very hard, I think, to comment on what the defense promised in opening and not also comment on, well, you didn't hear the defendant say. And you didn't hear the defendant say this. So the Commonwealth had told the defense, we don't intend to. The court said, I found some cases on this topic, and I think there are some limits, but that they can comment. And so the court is now shifting gears into that case law to talk about what the prosecution may be able to comment on based on her research. The prosecution may choose to stay full well away from it because I see the difficulty. And the prosecution can change their mind, of course. But I see the difficulty of how do you comment as the prosecutor on the fact that the defense said, you will hear evidence that the defendant got into bed with his wife. I guess the Commonwealth could simply say, you've heard no evidence of what happened between this time and this time, but also, I don't think the prosecution wants to make that argument. You've heard no evidence of a murder. Like, that's not what they want to say in closing. You've heard no evidence that Anna Walshe died of natural causes. I think that would be fine. It's not really commenting on the defendant's statements or lack of statements, but it becomes a very tenuous tightrope. Because if the prosecution misspeaks, it could cause a mistrial. That is one area where a lack of precision could throw the entire case out. Because if they burden shift, if they comment on the defendant's right to remain silent, it will fuck everything up. So they might just say, we're not touching it. We're not touching it, and focus on the evidence that the jury saw and let the jury wonder about those statements in opening and not talk about it. But the prosecution wasn't even thinking about that as of this morning, because as of this morning, the defendant was going to testify. So the prosecution hasn't even had time to really process all this new information and reset. So the prosecution might need a minute, but the court's going to put on the record the case law where the prosecution can comment on what the defense or comment on opening statements. So
Maybe there isn't an issue.
So that's
Maybe
what's
there is.
coming
But let
up.
me just tell you, we all know what I'm talking about, right?
I do. And now chat does. We're all singing from the same hymn book, Your Honor. The fuck's happening in that courthouse? That wasn't a siren. The fuck was that? That wasn't on my end, chat. That was in court. Did you hear that? You all did. Yes. 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 I backed it up. I don't know what it was. That was in court.
I know what I'm talking about, right?
Yes.
All right. So I'm going to give you some
And
sites.
there goes the bailiff. There goes the bailiff. I bet somebody's being sentenced in another courtroom. That way, if I had to make an educated guess, my educated guess is that somebody is being sentenced. Second guess would be that that somebody got a verdict.
Some cases, and I'm going to tell you preliminarily where I think the line drawing is.
Okay, one more time for those of you asking. Did you see how quickly the bailiff was like, nope, I'm out. I'm out.
Yes.
All right. So I'm going to give you some sites to some cases, and I'm going to tell you preliminarily where I think the line drawing is.
And there goes the bailiff.
And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on
Yeah, my guess
Tuesday,
is that's
December
from
9th,
another court.
or vice versa. So
Another
anyway,
courtroom.
here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96.
The defendant's expression has changed much throughout the day.
Mass App Court, 197.
There are multiple bailiffs in this courtroom, so I'm not surprised one of them went to go deal with whatever that was.
And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637.
The prosecution
in those
might
cases,
decide no.
the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments.
Right.
And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look
Right.
at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes.
That's fair.
I read the pleadings that just came through.
Remember the
And if that is where the line
Remember, the defense made a motion this morning And that's why the court is bringing this up. The defense made a motion this morning asking that the prosecution be limited from commenting on opening statements. And we've talked about why that's tenuous. The court has touched on the same things that we have discussed here. But I think it is fair to also say, under the case law, it would be fair if the Commonwealth said that there is no evidence before you that Anna Walsh died of natural causes. The defense is going to say there is no evidence before you that Anna Walsh died at the hand of Brian Walsh. So
Is drawn. You don't have to respond.
I'm going to start with her sentence with, I reviewed the pleadings.
And if that is where the line is drawn, you don't have to respond to this right now. I'm not, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure or the allegations of reneging on a promise are impacted.
It's hard, Your Honor, because it gets to commenting on the
Qualify that by
defendant's
saying I
right
read
to remain
the
silent.
pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I'm drawing the line, take a look at those cases and we'll discuss it again before the opening,
before the opening
closing
instruction.
arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
There is no evidence that Anna Walsh died of natural causes.
and of course,
That also came up in numerous cross-examinations by the defense, not just an opening. The insinuation was put out there in cross. Opening statements are not evidence. So the defense's opening statement that leaned very heavily into the evidence will show that Anna Walsh died of natural causes and then Brian Walsh freaked out, that's not the evidence in this case. And argument and opening statements are not evidence. But it was in cross-examination. The insinuation was there. So the defense is clarifying the judge's tentative ruling.
defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented I'm not going to go into right now. So let's just stick to this, if we may. So if the government's allowed to say what
I just said.
And of course, the defendant can argue there's no evidence that there was any homicide or any.
Expect you're going to.
Well, Tipton, what are you going to argue if not that there's no evidence of a homicide? That's what you're going to argue. That's what you're going to argue. What?
You can argue there's no evidence that there was any homicide or any.
Expect you're going to.
I shouldn't be here. But I can, once again, recite the evidence of such an unexpected death that came into evidence.
Did he just say, but I can't recite the evidence I expected to come into evidence that didn't? I think that's what he just said. I'm going to back it up a little. He was a little hard to hear.
Or any.
Expect you're going to.
I shouldn't be here, I suppose. But I can, once again, recite the evidence of such an unexpected death that came into evidence.
I couldn't quite hear him, but he's talking about sudden unexpected death.
Of such an unexpected that became into evidence.
I still can't hear him. We'll see what the
Or I
court
shouldn't
says.
be here, I suppose. But I can, once again, recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walsh. There's
Yeah.
no testimony before this jury that ties sudden unexpected death to Anna Walsh, is there?
No.
Judge, well, when the court asked me that, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so
Sir, the very, 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 very bloody evidence might disagree with you, but the defense is trying to say there's evidence of sudden unexpected death. There's not. There was a cross-examination of a coroner that people can die suddenly and unexpectedly. I think he can argue to the jury, we don't know how Anna Walsh died. People die all the time. But I don't think he can tie it back to the evidence. I think he can tie it to the circumstantial nature of the case, but we'll see.
causation of death should be fair game to argue because it's equally consistent.
But then it's argument, not evidence.
Citing that Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walsh. So,
counsel, with the amount of blood in the evidence, it does not stand to logic that Anna Walsh is still alive. So,
why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? I shouldn't use the word speculate.
correct.
Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't,
They can met out their burden with that circumstance. The
Yes.
law is clear there. They can met out their burden purely with circumstantial evidence.
Yes, they can.
They can.
Yes,
And
they can.
their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the evidence retrieved from the bags and other, the other distinctions in the evidence.
And I think it's fair. I think it's fair for the defense to point to people die all the time. We don't know how Anna Walsh died. You don't know. I think it's fair for him to argue to the jury, you cannot say how Anna Walsh died. And you definitely can't find it beyond a reasonable doubt to a moral certainty. You don't know how Anna Walsh died. Yes, you've seen Brian Walsh go to dumpsters. Yes, you've seen him go to Home Depot, but you don't know. And so he can point to the burden and he can point to the circumstantial nature of the case, but he cannot argue the evidence showed sudden unexpected death. And so there's a distinction between the two. And part of me wonders if some of this record is being made. This is just my speculation. Part of me wonders if some of this record is being made for the benefit, not necessarily of the court, but for the client. See, client, I can't argue in this way because there's no evidence or testimony that Anna Walsh was deceased in her bed. You heard the court say it. I can't argue it. I'm going to ask the court. I'm going to make my record. I'm going to see what the court says. And if the court says no, the court says no. So I'm not arguing it. So I don't want you complaining at me about why I didn't argue this, this, and that, because you heard what the court said. So some of this argument might be for the benefit of the client sitting at the table. He preserves it for appeal. The client hears it. He can do the closing he wants to do.
We've always argued, and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical
No, you don't.
examiner, that death can occur suddenly, unexpectedly, without injury, and it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified? It's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide.
All he wants, Your Honor, all I want is Wingstop. All I want to do is say it's possible, Your Honor. Well, he can say it's possible. You heard the coroner say people die unexpectedly. People can die unexpectedly. That's fair. It's nuanced.
So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not
true.
a homicide?
But there's evidence in the record before this jury that
What, Your Honor?
I don't want to interrupt.
Let the court's train of thought leave the station.
There was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, so we made a date.
so you could make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume.
But you can't argue that there is evidence that Anna Walsh died of natural causes. You can argue that there's no evidence that she died of a murder and that humans die of non-murderous causes all the time. And you heard the coroner tell you about all the different ways that people die. People can die in all different ways. That you can argue. Those two things are nuanced. So yeah.
That they are going to draw a line between some of the evidence that was retrieved from the bags.
Among
as
other
being
things.
Circumstantial evidence of things that happened before the dismemberment.
I agree, they will.
So, for example, the slipper, the blood in the hair.
Yeah.
I presume their argument is going to be that that happened before.
I presume the same thing, Your Honor.
That's circumstantial evidence.
Because that slipper doesn't look like that after the Tyvek suits are purchased. And it's pretty chilling evidence.
Because once the foot covers are
Keep reading, Emily.
purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
Ding, ding, ding.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented.
Yeah.
But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walsh died of some natural causes. I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument
I don't think he can. I think he can argue more generally. Liz Rose asked, EDB Leonard, has anyone seen a case where there's no defense case? Yes, it is actually, I think, more common that there's no defense case or like a defense witness than it is that there is a defense case. We just happen to cover a lot of more complex cases because those are ones the media are interested in. But day in and day out, most cases, 3-4 witnesses, defense puts on no witnesses and done. It's just not the type of cases that make it into the media, but it is what happens in courtrooms all the time. So it is incredibly common. The defense may be having one or two, but most defense cases rest on thorough cross-examination. And that's much more common. So a lot of cases take 2-3 days after jury selection. Some cases take 2-3 witnesses. I've had cases take a half a day, like 3 witnesses and you're done. So it really just depends. These cases are much, they're more nuanced. The cameras aren't going to roll out for a case where a guy comes in and testifies. As one of my trials. So I was doing thing in my day, and that person sitting over there walked up and stabbed me. And I said, "What the fuck?" And he said, "Give me your wallet." And I said, "No, did you just stab me?" And then he ran away. And I called the police, and then they arrested him down the block, and then he had a knife on him. And it was that guy over there. And then there's cross-examination, and then law enforcement comes in and is like, "Yeah, we arrested that guy. And when we arrested him, he had this knife. And he was down the block from where that guy was." And then you just do argument. But those aren't cases that make it onto the media. There's not, it just is. These cases are much more nuanced. This case has really complex legal issues, which is what we're seeing, why they're still arguing in court. And this case has, well, the facts are the facts. Baffle Waffle, that was a case that I tried. It's a longer story than that, but that is the summary of a case one of the cases I tried. And we picked a jury before noon, did all the witnesses afternoon, and the jury was done by like 4:30.
fundamentally would be that all of the evidence that the
But Tipton is definitely making a record.
Some natural causes. I'm just asking, what's the circumstantial evidence
To connect
upon
it to
which you
Anna.
base that argument?
that our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the
Mr. Walsh, your face is very different than your face was facing earlier in the morning. Oh, no, didn't happen to me. I was not the one who got stabbed. No, it was a case that I tried. But Mr. Walsh, your face is facing differently this afternoon.
not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death that the government is arguing is evidence of a homicide? Could be only evidence of an attempt to conceal evidence that a person, using the language and conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that, given the state of this evidence, we can argue?
Chad, I genuinely want to know, how many of you, we're not talking about whether or not you think that there is premeditation and whether or not you think there is evidence of a first-degree murder. We're not having that conversation. The conversation I am asking you now, chat and replay crew in the chat, do the things that you saw after the early morning hours of January 1st read to you like fear Or does what we've seen from the defendant's behavior read to you like covering up or consciousness of guilt? Because the defense is like, could be fear. Does any of this read like fear? Does the defendant seem scared at all about anything? Other than maybe how his hair looks in the monitor? The thing I think that looked like fear from this defendant is when he realized that the self-checkout at Lowe's had him on camera. That is the only time I saw him look concerned, and he moved out of the way. And he was wearing gloves and a mask. That is the only time I saw him look concerned. If the defense is going to argue fear, I think it's a hard argument to make.
Our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walsh die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright.
There's no evidence of that.
As is contained in the language of the Constitution. The jury gets this right. And it may, as is contained.
It's not your YouTube, it's my YouTube. There's a few words that are dropping.
In the language of the Constitution. The jury gets this right. And it certainly, the thrust of that argument is that it raises a reasonable doubt. And that's the evidence the jury heard.
Your Honor.
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right.
I mean, okay.
And that's why I was thinking we might find common ground here.
Sounds like we have.
I think the Commonwealth can say there's no evidence she died of natural causes. I think it's fair to say, I think it's fair to leave it at that versus the defense said they were going to show you X and they didn't. I think that's fair.
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
There's always
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that
So was the word clusterfuck then, Your Honor? Was the word clusterfuck?
the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now. All right.
The court. I thought we had a few days.
Take a look at the verdict slip.
Wrong.
Looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
no more than 45 minutes.
All right.
That sounds good, Your Honor.
So 45
What?
it is. I won't cut you off in a case like this, of course. I have cut off in other cases when it's a 2-day case and we're on 45, 47, but that isn't this case. And, but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good.
We like
As
those
opposed
fresh
to having,
jurors.
a couple hours of evidence in the bank and they're already tired.
Fair.
That's all I have on my agenda. Anything that you need.
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed. And I will then create a new draft and that will go out to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it. All right. Thank you. But one other thing that I want to say is that you can be seated.
Your Honor. But wait, there's more.
I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other.
I agree with her.
And as I say, I drop
Ooh.
into Norfolk County every once in a while as I drop into other counties. You and I, counsel.
Your Honor, do you have to ride circuit between the counties? It sounds like yes. That's wild to me. But then again, SoCal has very big counties, but riding circuit amongst the counties seems like a lot.
And I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate.
It is?
There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
Well, I appreciate
Continue.
your words, Your Honor. All right, the court was done fairly early in the day today. We started a little bit late. We had to instant replay a lot because I'm still buffering from today. Court is done for the day. They finished with the jury in about 5 minutes because the defense rested with putting on no witnesses of their own. And then because everybody was caught a little off guard by that, especially the court, she made that well known, they spent quite a lot of time going over the jury instructions. But you know what they didn't go over? What the homicide instructions were, because everybody agreed on them. But we still don't know what they are. So we're going to learn together when the court reads the homicide instruction to the jury, if the homicide instruction is just for the elements of first-degree murder, or if it includes the elements of second-degree murder. We're not going to know until the jury instructions are read because everyone agrees and they are not going over the jury instruction that everyone agrees to. So we're going to find out together tomorrow when the jury finds out, which is delightful for all of us. So, law nerds, your question is, what does the jury have to decide tomorrow? They have to decide if Brian Walshe committed the murder that he is charged of, which is a first-degree premeditated murder. Will they be given the option to downgrade that, from premeditated first-degree murder to second-degree murder? I guess we'll find out tomorrow, because we're going to find out tomorrow. So what's going to happen tomorrow? Tomorrow the court is going to come in and do the work with the attorneys, make any modifications needed to jury instructions, because everybody was caught off guard that they were needing to be done today. Make any edits that need to be made before they get to the jury. The jury will come in and the court will spend 45 minutes to an hour reading the closing jury instructions to them, telling them how to decide the case and what they need to decide. And then the attorneys will make their closing. Remember, in Massachusetts, I forget this all the time, so remember, to me and to you, the defense closes first. So we will hear the defense closing arguments, then the Commonwealth. Other jurisdictions split it, where you hear from the Commonwealth or the prosecutor, then the defense, then the prosecutor. Here, we will hear from the defense and then the prosecution, and then they will get their final charge, and then they will go back to deliberate. I do not think that this is a case where I would expect to see a verdict where they're ringing the bell before all the evidence gets back to them. Remember, the jury is going to want to go through the instructions again. This is an entirely circumstantial no-body case. They are going to want to talk about it. And there are text messages from William Fasto that the jury has not seen yet that are in evidence that they're not going to get to read until they go back in evidence. So there might be things in the evidence that the jury wants to go back through. Remember, the jury's going to have a binder, like a giant binder of all of the Google searches. Not all of those were read in. There may be someone on the jury, or some numerous someones on the jury, that want to go back through and see those again and see them in order. So there are going to be things that the jury needs to look at tomorrow. So if the jury's not back within an hour or two or what have you, I'm not going to be shocked. And I will not be surprised if the jury does not come back with a verdict until Friday. It is an entirely circumstantial case. If the jury wants to go home and sleep on it before they come back on Friday and make a final decision, I will not be surprised. So we'll have to see what happens tomorrow. Oh, tomorrow is Friday. Oh, that is right. Emily, tomorrow's Friday. Well, will the jury want to take the weekend? I don't know if the jury's going to want to take the weekend. I've forgotten what day of the week it is. Yeah, the jury might not want to take the weekend. Then again, some of them might. Thank you, chat. Chat is bae. Remember, the language in Massachusetts is beyond a reasonable doubt and to a moral certainty. Some of you might still want to hear what the prosecution has to say about how are you telling me this is premeditated? And what does that mean? Some of you might be like, I am done. I have seen the evidence. And some of you might be like, how do we know what happened? Those conversations can take time. So we'll see what happens tomorrow. We'll see what time the jury gets the case. They really might want to take the weekend. Then again, some of them might be like, it's the holidays, we're done. It's just going to depend on what happens tomorrow, because court is unpredictable and we don't know what's going to happen tomorrow. But the evidence is closed. The jury is getting the case tomorrow. There is not an opportunity for the defendant to come back in and be like, and now I want to testify. But there are still difficult questions for the jury to tackle. It is the unusual case where the jury does not have an autopsy to point to talk about what happened and how the evidence is presented to them, how linear the timeline is for them is going to help. Because there are things that happened early in trial that I am sure I've already forgotten about. And there's a lot of details in that tech evidence that I'm interested to see how the jury pulls it out and parses it, truly. And how the defense and Commonwealth argue. I'm looking forward to closing, Both sides have said they need about 45 minutes. The court said she's not going to cut them off. I think that's fair. So closing arguments for a couple of hours tomorrow, and then the jury's going to get the case. Well, and lunch. They're going to take lunch. So if the jury only has about 2 hours, I don't think they'll come back with a verdict. I don't think 2 hours will be enough time for them to discuss this. Maybe it will. Maybe they're over it. But it's asking a lot of the jury. So it just really depends what time they think they're going to get it. So with that, don't forget to get the Law Nerd app. We're going to answer a few questions. I think we've answered a lot of them throughout the day. Don't forget to get the Law Nerd app. Do not forget to go to the FAQs in the Law Nerd app to find out how to turn on your notifications. There are often times that we are scrambling to get live to hear the verdict together, and we will notify you in the Law Nerd app when we hear of a verdict, because we are going to be on Verdict Watch tomorrow. Free on iOS and Android, Law Nerd app at lawnerdapp.com. Turn your notifications on so that we will make sure that you know when we are going live for a verdict. Some of you are asking what's the fastest verdict I've ever seen. It's different in a homicide case. A case with 2 witnesses and a jury comes back with a verdict where they just like push a button before they even get the evidence back is different. It really depends how long the case is. And this is a longer case. I'm not traveling tomorrow. I'm not going anywhere tomorrow. I am sat down tomorrow with y'all. So we will chat. Don't worry. We will have lots of time to chat. I'm very curious about what's going on with the lesser includeds. And if there are, it might not be. They might just go forward on the first degree premeditated murder and not give the jury any other option. It is or it isn't. So we will see. And I have so many questions like this from the chat. Zachla, I think. Zach LA, maybe. Can the state still add the second degree murder lesser charge to consider? Yes. But we haven't heard any conversation about it. So whatever they're doing, they all agree. Ida Crow 7694 said, could we get a verdict tomorrow? We could. Though I won't be shocked if they need a night. But since it's the weekend, the jury might be like, I don't want to come back and do this on Monday. Or the jury might be like, I'd rather be on jury duty next week. Let's just come on back. It depends. It really depends. Long Island Hillbilly asked, do you think Brian picked New Year's as the perfect holiday to commit murder? I don't know if New Year's Day was because it was New Year's Day or because he had the time with mom that was already accounted for, or if this was more spontaneous. I have my thoughts. I'm very curious to see how they put together the timeline in closing. And again, this is why jurors are 12 and they have a conversation. Because there are so many times when I see something one way, even when I was on the live stream with Dr. B and our members only, I was like, oh, I read this way. He's like, oh, I read that way. I was like, oh, I didn't even think of that. That's a great point. I see what you mean. I see that interpretation. That's reasonable to me. And so this is why jurors have to have conversations, because what might be your gut reaction to something after closing might change when you talk with others. So I'm very interested to see what the closing arguments have. I also am not beyond the possibility that there is going to be a juror that is like, I am struggling. If you can't tell me how she died, I am struggling with convicting someone of first degree murder. That is a very real consideration. But I also wonder if the house arrest information about him planning for more time on the first is going to be evaluated by the jury as premeditation. Premeditation does not have to be weeks in advance, days in advance, hours in advance. It doesn't even have to be minutes in advance. Premeditation can be moments It just needs to be a decision. Let me grab it real quick. Let me see. I've got a few of the model jury instructions here. And of course, we are not going to have the exact language until tomorrow. And some of you are asking about first-degree murder in Massachusetts. First-degree murder in Massachusetts in this circumstance needs to be premeditated. But murder with extreme atrocity or cruelty, they have a circumstantial case here, so they can't really argue that. And felony murder is not the circumstance here. So there are options for first-degree murder, but the only one that fits this fact pattern is murder with deliberate premeditation. Let me pull it up real quick, and we'll just talk about it for a moment because I think it will help. And then we'll see, of course, the language as it's presented to the jury tomorrow. Where is which page is it? Hold on. Murder with deliberate premeditation, page 31. Emily, just control F yourself to, it's command F yourself, but command F yourself to page 31, please. So we don't have to scroll. Let's zoom together. This is the model jury instruction. This does not necessarily mean it's the one they're going to read. Oh, all these case sites with 31. At least it's not 6, 7. All right, 28, 29, 30. 31, murder with deliberate premeditation. The court says, I will first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of the victim, Anna Walshe. The defendant intended to kill Anna Walshe. That is, the defendant consciously and purposely intended to cause Anna Walsh's death. The defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. No self-defense, no mitigation. I will now discuss the requirements in more detail. There is no evidence of an accident here. There's no evidence of transfer intent here, so we're not going to go through those. Alcohol consumption is not at issue. Self-defense is not at issue. Mitigating circumstance is not at issue. Where is just our... we've got to get through the other ones. This is why they have to edit them so much. We don't need felony murder. We just need our definitions of premeditation, please. This is why I don't do these on the fly and prepare them in advance, but y'all are like, no, we're good. Let's just pull it up. This is the third element. We don't need the third element for felony murder. Where is the intended to do the act? No, not murder in second degree. Jury instructions. Where is me asking the jury instructions? Please speak back to me, jury instructions. Where is your premeditation definition? A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, which would not have otherwise occurred. The second element is the defendant intended to kill the victim, purposely and consciously intended to cause death. There we go. Third element. I jumped over it. The third element is the defendant committed the killing with deliberate premeditation. I zoomed too fast. That is, he decided to kill after a period of time, and these have a toggle between he, she. They change. I think one day we'll just change all of it to they, so they don't have to worry about going through and selecting, but I'll talk about that another time. It's where typos occur all the time. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. This is the language the defendant wanted taken out, or the defense wanted taken out, and it's not being taken out. That has to be in there. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. If the Commonwealth argues that the defendant chose to grab a knife, that is enough time. Leaving the bedroom and choosing to grab a knife is enough time. And I think the evidence between the Google searches and the varnish on the floor are enough evidence that the Commonwealth could argue that the defendant chose to grab a knife and then either in the living room, in the bedroom, because in the bedroom, the varnish was off the floor and he was Googling how to get blood out of a floor, and getting that blood out of the floor left the varnish removed from a circle on the floor. Choosing to go and get the knife is enough time to deliberate. You're making that action. So, with that, we will see the argument about the seconds. There's no evidence that there was any blood or anything like that in the kitchen where a knife would be. M in the chat asked, isn't all murder premeditated then? No. Without getting too far afield, there are plenty of circumstances where you end up with a second-degree murder because the action was volitional, but they weren't intending to kill. I gave some of those examples earlier. There are circumstances where someone is reckless to the possibility of death, like Alec Baldwin. When you look at that, there was a reckless disregard that was being argued there when Alec Baldwin, he didn't intend to kill the cinematographer on the movie set. He intended to point a weapon at her and pull the trigger. He did those things, but he didn't intend to kill her because he didn't think the gun was loaded. But was that enough of a reckless disregard for human life? So that was in the manslaughter range. The example of pushing someone and they hit their head on a table or something. You didn't intend for them to die. You intended to push them, and then things happen that cause them to die. And then you get to a lot of other circumstances involving, reckless driving can end up in the homicide range depending on the driving, even if when you get into a car, you're not intending to kill someone. So there are lots of circumstances. And when we look at the Sarah Boone case, Sarah Boone said over and over, well, I meant to zip him in the suitcase. I mean, I didn't mean for him to die, but it was a reckless disregard when the victim was saying, I can't breathe. And she was videotaping herself taunting him. Now, I think there was an argument in the Boone case for a first, but Florida didn't need it, so they didn't go for it at all. But Sarah Boone saying, when I zipped him into the suitcase, I didn't intend for him to die. And I think it's fair to interpret it that way. But then she didn't give a shit, and he died. So that was charged as a second. So there are lots of circumstances, which is why all case law is very fact-driven. If this law, then these facts, then what? If this law, then these other facts, then what? So continuing on into just a few questions before I have to zoom. Carrie Reed said, do cases without a defense ever win? Yes. The prosecution has to meet their burden. Do not underestimate Tipton. I don't think any of you are. But Tipton is going to spend all of his closing pushing on the Commonwealth's burden of proof. And they are going to try to make the burden as big as possible. Big, huge, all. The problem is this is also a very bloody case. And the Googles. And I think that the Commonwealth can argue that you don't have to look too far to know that this was a murder because Brian Walsh's own Google searches tell you that this was a murder. I might open, if I was the Commonwealth, with can you be charged for murder without a body? Yes. And that's why we're here. The defendant didn't want to be here, and that's why he dismembered and disposed of Anna Walshe after he murdered her in their home. And you saw from his slippers and where the knife was stashed. I would not do this in this order. I'm giving you my checklist. Slippers, where the knife was stashed, early Google searches. This is how you know that he knew that it was a murder. And this is how you know that he didn't want to get caught. The Google searches go from getting blood off a knife, getting DNA off a knife, putting things in the dishwasher, cleaning blood out of the floors, to how to dismember a body, how to dispose of a body. First, cleaning up the murder. Second, getting rid of the body. And that, I think, is where the Commonwealth can start to make headway on that. Why was the knife treated differently? Well, because he cut his thumb on the knife when he used it to murder Anna Walshe, and he knew that his DNA and her DNA being on the knife was a problem. That's why he went and got a Tyvek suit. But he didn't count on the Commonwealth finding his slippers, because his slippers are covered with the victim's blood and hair before he gets the Tyvek suit, because that happened during the course of the murder. That's why he needed to figure out how to get blood out of the wood floors. That's why the knife is above the refrigerator. That's why the knife looks the way it does. Because he made sure that DNA could not be recovered from that knife. Once he got the Tyvek suit, he wasn't worried about his DNA. It's there, but he wasn't worried about it. That's why his DNA is not on the hatchet and the hacksaw and the hammer and the snips and the other snips. And where did all the buckets go? So I would use the time frame of the Google searches and the time frame of his actions, the knife and the slippers, and the Band-Aids. And that's where I would start my closing arguments, with his words. And I would end it with his words. And there's stuff in the middle. And for the defense, can you decide to a reasonable certainty, to a moral certainty, to the heaviest burden in any court known to man, how Anna Walshe died? Ask yourself that. Do you know how Anna Walshe died? You don't, because the Commonwealth didn't prove it to you. They're going to insinuate stuff about Google searches. Who hasn't Googled? But what they can't show you is how she died. Now it opens up the door for the Commonwealth to say, we can't show you how Anna Walshe died because he made sure we couldn't. And he Googled, can you be charged with murder without a body? And that Google search went darker. Can a body be identified without teeth? It tells you what he was thinking. And Anna Walshe's friends told you what she was thinking. In the days leading up to her murder, she was thinking that she was falling out of love. She was thinking that the defendant wouldn't take responsibility for what he had done that kept him in Boston when she had to take another job in DC because they were facing $500,000 of restitution. And she was living away from her 3 young kids, commuting back and forth, and was frustrated that he wouldn't close that chapter. And she told her friends that she told him that, and she had reached a breaking point. And it seems that Brian Walshe also reached a breaking point. Anna Walshe was frustrated. Brian Walshe was a murderer. And he told you that with his Google searches. And when did he have time while he was on house arrest to go do all of these things? On January 1st. The time he had set aside to take his mother home. His mother that wasn't there on December 31st because their family friend, Jem Mutlu, told you that she wasn't there. So why did he need that time? And why did he ask for it on December 22nd? Why did he need a new iPhone SE? Why did he tell everyone the iPhone 13 was gone when it was being plugged in and unlocked in the time he said it was lost under one of his kids' beds? Why get another phone? And let's talk about where the iPhone SE went. The iPhone SE went to Lowe's and to Home Goods and to Home Depot. The iPhone SE was with the defendant when you saw him at the dumpsters, on the security camera, paying for things with cash, wearing a mask, and wearing gloves, not winter gloves, wearing gloves. Why? So that you couldn't trace it? The cameras traced it. Y'all saw it. So on December 22nd, he tells his probation officer that he needs 6 hours on January 1st. Same day he gets the iPhone SE. What was he planning to do on January 1st? The last time that anyone heard from Anna Walshe, who he put into dumpsters all around where he lived, with the iPhone SE telling us exactly where he was. And we know he was at all those stores because we saw the things in the house. And the defense is going to lean in to, you can't be certain what happened to Anna Walshe. You don't know what happened to her because she's not there. But it opens a door for the defense, doesn't it? It really does. So when the defense leans into the burden of proof, I think the defense is looking for a few jurors who are unsettled by the unknown. Because the defense is going to say, probably more than once in their closing, that the jury instructions say if there are two reasonable explanations for a thing, you must pick the one that says not guilty. And if you can't say how Anna Walshe died beyond a reasonable doubt to a moral certainty, if there was more than one explanation, more than one reasonable explanation, you must pick the one that says not guilty. You must. That's what it says. You must. That's your duty. So when you go back to deliberate, ask each other, how did Anna Walshe die? Now you run the risk that somebody is going to say, with the fucking knife in the bedroom where the varnish is gone. You run the risk. You invite the jury to say that. But you might also have a juror that says, I can't say what happened. So how do I get beyond a moral certainty? And to that I would say the Google searches. But you know what I would say? Because, well, I've told you both sides of what I would say. Tipton is a very good attorney. He is going to lean in to, if there are two reasonable explanations, you must pick not guilt. Burden of proof, burden of proof, burden of proof, moral certainty, burden of proof. Burden of proof. You don't know how she died. You don't know what the cause of death is. Anything could have happened in that house. Anything includes murder, but anything could have happened in that, not murder. Anything could have happened in that house, but not murder. And the prosecution needs to connect the dots. So, closings are going to be interesting. I have soliloquied, I apologize. But it's going to be interesting to see how they tie it together. But it's going to be difficult for jurors to look at the defendant carrying bags and throwing them into dumpsters after purchasing a Tyvek suit and a hacksaw. It's going to be hard for a lot of people to say, this is not what you do to someone you love if you did not kill them. This is not what happens. If someone you love was non-responsive and in distress and you don't know what happened, you call the police. It's going to be hard for jurors to overcome the logic. And some of the jurors, let me know if this is you at home watching this case, some of the jurors are going to be stuck on the fact that they talked about the fatty tissue residue on the hatchet. It is beyond DNA. It is beyond red-brown stains. And it's incredibly visceral. Plus the 2 Tyvek suits and all those missing Home Depot buckets. It's going to be hard for jurors to overcome because it is so horrific. And the defendant bragging on himself to the police about what a great fundraiser he is, what great charity work he did, is starkly contrasted by those that loved Anna Walshe and the way that they talked about her on the stand. The way that the witnesses yesterday spoke about Anna Walshe is a complete contrast from the way that the defendant spoke in any of those police interviews. And the difference is stark, for lack of a better word. So tomorrow we'll, excuse me. I've literally choked myself up. Apologies. Tomorrow's going to be interesting. To everyone who gifted memberships, thank you. I appreciate it. To everyone who's saying, yeah, it was the leak-proof buckets from Lowe's. Why do you think the prosecutors chose to put that in last? I don't think that was a scheduling call. I think that was a strategy call. There is a reason they left the Home Depot evidence for the end. So where the fuck did all that shit go? The reveal of the second Tyvek suit, because I was sitting there looking like, that's a pretty clean suit. It's got his DNA on it. It's got some of her blood on it, but that's a pretty clean suit. There was another suit. Oh. Well, where the fuck did that one go? And what did it look like? Because that was never recovered. And then the Band-Aids. There's a lot that the prosecution has to work with, but there are legal nuances. I think how visceral some of the evidence is might make it hard for jurors to overcome and really get into the legal nuances, because why all the dumpsters? If not a murder, why all the dumpsters? And some jurors might say, but how do I know there was a murder? So let's see. We've got a lot of you gifted memberships. I'm sorry I didn't pull them all up. I just realized what time it was. Some of you have asked about whether or not they had evidence. I saw the super chat from Julian. We do not have evidence about the trash being incinerated. I do not know. Massachusetts residents, will you let us know if that is common knowledge to you or not? I don't know if it's, hey, they understand. I don't know. Millie said, sadly, this is a better closing than we'll see tomorrow. I don't know about that. I have faith. Well, I try to maintain faith that everyone will do well, but closing arguments were my favorite. Shock. I'm sure you're shocked. All of you are shocked. I liked opening statements, but closing arguments were my favorite. Absolutely. Rachel asked, did they have dinner plans on the 1st? Could that be why he asked for the free time? Rachel, I had forgotten this detail. This is a great question, because Anna told the woman at the nail salon that she had dinner plans. And when Anna told the woman at the nail salon, that they had dinner plans. I think the prosecution went the direction of, but he would have to get special approval from the court. Do any of you think he would get special approval from the court to go to dinner? Nah. But it's in evidence, and I think the defense will probably argue it. That's a great detail, Rachel, that I had forgotten. Thank you. They did talk about it a lot, and I think the defense will bring it up. Anna said that they were going to go to dinner. Do you think Brian Walshe is the type of dude that would lie to his probation officer and say he was taking his mother to take his wife out to dinner? Maybe. But the phone. But then what about the phone? Because, yeah, I definitely think Brian Walshe is the type of dude that would just be like, I'll just say I'm taking my mom. Mom's not going to dime him out. I have a lot of questions about mom, but mom's not going to dime him out. I mean, Diana, why are you giving Donna, girl? I got some questions. Is that why you're ignoring your civil lawsuit? Emily, this isn't helpful on the no speculation. I know. It's not helpful at all on the no speculation. So why would he lie to go out to dinner with Anna to try to save the relationship? Sure. Will the defense argue it? Probably. Ladies and gentlemen, there's a reasonable explanation for everything up to the Google searches. We have a reasonable explanation for everything until the Google searches. And then shit goes off the rails. We've got nothing after that. But before the Google searches, reasonable explanation. He just wanted to take his wife to dinner. It's a great point. This is why Chad is bae. You guys are the best. So, Racer Girl, you are welcome. You are welcome. You are welcome. Gringa said, is the issue the difference between indirect and circumstantial evidence of murder versus pure speculation on natural causes? Yes, that is what they were grappling with in the jury instructions. The jury is allowed to make reasonable inferences from the evidence. However, I want to make some unreasonable inferences because the mom got a psychic, and was it really a psychic or was it a PI? And did the mom lie to Brian and say it was a psychic because she didn't want to admit that she had hired a PI because it might piss off her son? Or did Brian know it was a PI and was ceding to Anna that it was a psychic to see how she responded? Was that a test? Was he testing her? Because you're not going to tell me that the call to William, while William and Anna were at dinner, was not a test. No. Mm-mm. Or did the psychic and the PI never happen and it was still a test? I don't think it matters. But I sure want to know what else Alyssa knows. But we're going to have to wait until this jury comes back. We'll see what they do. There is stuff for this jury to grapple with. I will also remind you and ask you two questions. One, aside from chatting in the chat with each other, have you guys been talking about this case elsewhere? Because I would guess you have, and that's perfectly fine. No shade. I think that you are. Remember that the jury has not gotten to talk about this case with anyone. Not with their friends and family, not with their spouses, not with each other, not with anyone. They have gotten to sit and watch the evidence. They have not gotten to do the instant replay like we have. And they haven't gotten to talk it through the way we have. It is going to take them longer because they are starting at talking it through. We start talking it through before opening statements even begin. They have not gotten to talk it out at all. They haven't gotten to listen to anyone else's thoughts about the case. They haven't gotten to verbally process their own thoughts about the case. They haven't gotten to do any of it. Tian in the chat said, was the nail appointment the 31st? Yes. The nail appointment was on the 31st. So we've had some time to hear other people's opinions, to hear how other people see the evidence, to talk with one another. I mean, to chat and talk with one another, to ask questions, to be like, oh, wait, what about this? Oh, wait, what about that? Oh, shit, I forgot about that. I'd completely forgotten that Brian Walsh's phone that was missing was plugged in and not plugged in and turned on and unlocked and all that. Completely fucking forgot. And those are the things that they deliberate with when they have those conversations. So we've had a lot of time to talk about this case, more so than others. And so we need it. And the jury's going to need it too. So Lola the good dog said, remember, the answer to everything is, it's Massachusetts. It's Massachusetts. MJ said, wait, I missed what the chat explained about probate. The chat explained that probate was related to Brian Walsh's father. The jury doesn't know that. I suspect the prosecution won't argue it. If the prosecution knows that the probate was related to Brian Walsh's dad, they're not going to argue that, see, he already knew his wife was going to be dead and he planned to go see the probate attorney. It would be completely improper and inappropriate and would cause a mistrial because it is a inference from the evidence that they know to be otherwise. But it's not in evidence. It's just dangling. Oh, and he needed this amount of time to see the probate attorney. And if I was the defense, I would be pissed that that was out there dangling, because the jury is going to come to some conclusions and they are not going to have any other information. So that's difficult. Is it Liza Lindemark? Lindemark? I hope it's Liza. It might be Lisa. I hope I have pronounced it properly one of these times. So the defense didn't know he wasn't going to testify until today. I mean, either late last night or early today. But the defense planned their entire case around him testifying. They planned their whole opening. I do not think that Tipton, and I might be wrong, this is vibes and speculation. I do not think Tipton is the type of attorney who would push that line of telling a jury the evidence will show this, this, and this, and then know that it wasn't coming in. It would be unethical to do so. And I don't think Tipton would do that. I think the defendant all the way along said, 100% I'm testifying. I'm explaining to them. I found my wife deceased. I freaked out. And Tipton was relying on what his client told him. I don't think he would have made those representations to the jury otherwise. He looked deflated today. He looked frustrated today. And nothing about the way he's handled himself in court would indicate to me that he would do that. It just kind of would confound me. Some other attorneys, I might say I have questions. I don't think Tipton would. I think Tipton was also caught unaware and concerned. So I do. I think Tipton, I agree with all of you that Tipton looked deflated. Tipton has been really transparent and has worked well with the court. He's incredibly smart. And I don't seem that he would, I don't see anything that indicates to me that he would push that line, because we saw him zealously advocate. We saw him argue, hey guys, sometimes you need to put another word in there to get a better result on the Google searches. Sometimes you just got to add the murder word so that it doesn't tell you that you need to call like the police. Like sometimes when you're trying to dispose of a body, you got to the Google searches weren't algorithms. Am I right? Like the Google searches just weren't quite right. You had to be just a little more specific. it was just for the algorithm, everybody. We saw him make some arguments that were a reach of zealous advocacy, but we did not see him do anything that would even come close to being not above board. Stretch on the argument, good lawyering. Stretch on the ethics, bad lawyering. And I don't get that from Tipton at all. So I think he's been great. My frustration with Moments with all of the lawyers is always going to be what it is. Who has never watched, well, sports? We can analogize to sports. Who has never watched sports to not find frustration? It's the same. Why did you make that play? Ref, why did you make that call? I can see it without my glasses. Emily, I feel like you yell that at refs. I might be a little bit of a ref yeller. I try not to, but I might be a little bit of a ref yeller. I know they have a hard job, but sometimes also, did you not see? Come on. But I think the attorneys in this case overall have done a very good job. I think the court has done a good job. I don't always agree with the court's rulings. I was particularly frustrated with everything going on with Jem Mutlu. Very, very frustrated. I didn't like all the court's rulings. I did not agree. I was very upset. But I think they've been great. I really do. I think they were transparent with one another. I think they worked well together. Tipton was creative in ways I didn't quite expect, which I enjoyed. This case is incredibly sad. But one of the things I love about watching trial with all of you is that we get to see lawyers on their best days, on their difficult days, on their I'm trying, Your Honor days. And I always want to see lawyers be excellent at what they're doing. Same with sports. I rather see an evenly matched game than 75 to whatever, 0. I want to see an evenly matched game. And I think that's really part of what was so frustrating about the Karen Reed case is that the way that the Commonwealth comported itself with turning over evidence did not feel evenly matched from the beginning. I think there was some lawyer mismatching as well, but I don't think that the way that the Commonwealth handled their evidence felt like it was evenly matched. Everyone should start out evenly matched. There shouldn't be surprises and like, whoopsies, there's video. Oops, it's fucking inverted. Oh yeah, that camera, that one's completely fucked. It needs like an exorcism. It was built in 1870. This camera has been around since before Massachusetts was a colony. I don't know what to tell you. That case did not feel like it started out evenly. This case felt like it started out with everyone on the same footing, as best as one can be with the evidence being what it is. It felt like the judge was conscientious and nuanced. And I think yesterday was probably the only time there was a like, hey, by the way, this witness just told us this. Because remember, there was a really long sidebar before Jem testified. And then when Jem did the voir dire, they were talking about, you just told me this at lunch. I think that was the only thing that came up where it was like, oh, hey, defense, this is a new thing. And they talked about it in the voir dire. And I think the court was overly cautious with the testimony of Jem Mutlu. But again, when you're talking about the defendant's constitutional rights, I would rather the court be overly cautious than underly cautious, even when it frustrates me personally, because I want to hear what the witness has to say because I want to know. I'd be nosy. Like, I want to know. I want to know. And after years of a prosecutor, I'm used to knowing everything. All the things. Even when it wasn't my case, I could just call up a friend and be like, dude, what is going on with that case? Tell me, I want to know everything. So even when that came up, it seemed that the prosecution immediately told the defense they got to do a voir dire and it was just handled. because hiccups will happen. But no one should have their, whole body on the scale of justice so that the defense doesn't have what they need. It was a professionally tried case. It was it was nice to watch the attorneys do their work, even though the facts were incredibly difficult. And it was nice to see a different Massachusetts judge, I got to be honest. I'm going to leave that there. Leave that there. It's like yesterday when Miss Kirby was asked to talk about the phone call with the mother, and she went, well, yeah, that's how I felt. That's exactly how I felt. So, law nerds with all of it. I am going to talk to Dr. B. I don't think there's anything we have to do in the morning related to cars or anything. I am going to endeavor to be here with you so we can do the closings closer to real time and maybe have a little zoom in the jury instructions. Because what they're probably going to do is like an hour of reading the jury instructions, which we could do at 1.25. And then they're going to take the morning break. And then they're going to start closing. Hopefully both closings will get done before they go to lunch. But it might be closing, lunch, closing. And that's going to make the day real long. So I think, well, let me talk to Dr. B. Either way, I don't know. Emily, if you promise earlier than normal, you're going to be fucked either way. I think it's hey, law nerds, we're going to let you know in the Law Nerd app exactly when I am going live. And I'm going to endeavor that the time I go live will be as close to the time that it says on the stream as possible. For that, because I want to see the closings closer in real time and watch them with all of y'all. So I will talk to Dr. B, make sure the car stuff is handled. Once that is handled, I will populate a time. I will send you a notification in the Law Nerd app. Don't worry, this doesn't mean we're not streaming next week. Who knows? We might be on jury watch. We might be on verdict watch tomorrow. Then again, we might just be on verdict watch all night. Dr. B looked at me yesterday and was like, so In-N-Out opened locally. I'm like, boo, I love you. I am not sitting in an In-N-Out drive-through line for like 4 fucking hours. So we can wait. Because he's like, should we go to In-N-Out this weekend? I'm like, I'm okay. I can wait a month for a Flying Dutchman. What I can't do is wait 4 hours in my car for a Flying. No. No. So by the time they start closing, I expect that we will be able to catch up in real time. Get the Law Nerd app. Turn your notification on. I will see you tomorrow. Law Nerds. Since the judge gave everyone homework, see what you think the attorneys are going to say for your own personal, what are they going to say in closing? Burden of proof. Slippers. Circumstantial. Knife. What are we going to hear them say? How many times are they going to say Google? I think we're going to hear that word quite a lot. Google's like, I would like to be left out of this conversation. Nope. Not until it gets replaced with ChatGPT. Because that's coming. Can you just wait? Just wait till we're in court and what we're watching is a real-time recording of ChatGPT conversations. Because there's one case that is on my docket that is pending that involves ChatGPT already as evidence. So what happens when the Google searches become ChatGPT conversations? You are going to start to see those in real time. Miguelina, yes. Did Nightline air? Oh, good. Oh, Law Nerds will also share my Nightline episode. I have no idea. I haven't seen it. But I spoke with ABC about Jen Shah's release. So if you are interested in something that is more housewives and fraud, but housewives, we'll share that link too if you want to go take a look. So it is up on YouTube and we can share that. We'll share it in the app and I'll link it down below too. So if you guys want to go take a look at something else, we will. And don't worry, next week, when we are not on verdict watch, there is still things to talk about. and then we'll take the holiday break. Law nerds, you are the best. Thank you for being here. Thank you for being a law nerd. Closing arguments tomorrow, y'all. I guess we don't need our when will Brian Walshe testify question anymore because the answer is fucking never. So I guess my question is, did he plan it? Did Brian Walshe plan to watch everybody scramble around court today trying to figure out what the fuck they were going to do? Or was it a game time decision? I'm curious about your thoughts. Emily, we don't always speculate. I want to speculate about this. Send it. Let me know what you think. I'll see you for closing tomorrow. Bye, Law Nerd. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.